Good afternoon, and thank you for joining us. I'm Erica Hernandez for this special edition of Open Court. This is for the live stream before the trial of three former SAPD officers who are charged in the shooting death of Melissa Perez back in 2023. This is a case we've obviously been covering extensively for the past now 16 days. That's right, you heard that right. Today we'll start the 16th day in this trial of hearing testimony and evidence. We're kind of going to review everything for you and what's been going on, especially the last couple of days of last week, and just where we're at now and what we could expect in the coming days as well, and just how much longer we could expect this trial to be going on. I wanted to talk about some key points so far, especially from Thursday and Friday of last week. The state did rest on Friday after 13 witnesses. That last witness, which was the lead detective on this case, had been on the stand for most of the week last week, and he went back and forth with the state and the defense. There was some key moments there in that testimony that I want to talk about a little bit. And one of those things that that was brought up to, when he said about his investigation and what led to filing charges, he later kind of backtracked in his testimony, talking about how there was how do I say this? His analysis of the investigation, he was kind of backtracking on. He has said at times that after seeing some of, not all, he said only saw like 3 of the body camera footage, that he thought she was further down and closer to the hallway. But we've all seen the footage. I know if you've been following along, it's been shown over and over to the jury and to us during the live stream and during this case, just how much closer she was to those officers. Mind you, there was still a barrier between her and those officers. And for those who may not know, those 3 officers, Nathaniel, Villalobos, Alfred, Flores, and Eleazar Alejandro, are all facing first-degree charges. 2 of them are charged with murder, and 1 is charged with aggravated assault by a public servant. Those are all first-degree felonies, so they all face the same range of punishment if they are convicted, which is up to life in prison. Now, back to with the state's last witness. Again, I don't think I've seen a witness in a long time be on that stand as long as he was all of last week, most of all last week. But after him, the state did rest on Friday. Then we got to something interesting on Friday. While it's not uncommon for defense teams to ask for what it's called a directed verdict, we were kind of, wondering if a judge would actually grant one, which is a little bit uncommon here in Bexar County, is one being actually granted. What that means is the defense did not think the state had done enough to prove their case, and that they wanted the judge to make a decision and basically grant them a not guilty verdict then and there, which is called a directed verdict. That's done by the judge. It doesn't get to the jury. There was a lot of argument going on between the defense and the state about how they felt about this, but in the end, after about, I would say, an hour of going back and forth and trying to prove, the defense trying to prove that they should get a directed verdict, Judge Juan Rangel ended up not granting it. So that means then the defense started their case, and during opening, defense attorney Tom Nesbitt, he put on a really good opening about what the defense was going to do, and it was going to be a kind of a joint defense case. Kind of talked about this at the beginning of the trial and how this would proceed, and a lot of what they've been doing has been a joint effort, all 3 of them together. So there's going to be about 3 to 5 witnesses that the defense calls up. But that first witness I want to talk about that is still on the stand now is retired Detective Mark Duke. That name may sound familiar to some of y'all. He was an SAPD homicide detective for many years here in San Antonio before he retired. The last time we kind of saw him on a high-profile case, if y'all remember, was back in 2021 when Otis McCain was on trial for shooting and killing Detective Benjamin Marconi. Back in 2016, he was the lead detective on the case. We saw him testify then. So it was really interesting to see him on the other side of the aisle. Even he himself said, I would never testify for the defense, but saw this case and decided I needed to offer my help in it. So he has a lot of expertise. He's handled a lot of cases here in Bexar County. So he is on the stand. He started on the stand on Friday afternoon. Some of the key things I want to point out that he said, especially about how this investigation was conducted. Jason Goss, one of the defense attorneys, asked Duke whether Soto would have been assigned the Perez case as his first deadly police shooting case during the time of Duke's initial beginnings. He says, well, theoretically, everyone has to have their first case at some point, but this could have been his first case, but you would want to make sure that there is someone certainly on the shooting team that has a lot of experience and shadow him. He said, yes, he believed that this should not probably have been Detective Soto's first case as an investigator in the homicide unit. This was a big case. We all know how big this case was. So I think we saw some of those inconsistencies as when Soto testified about the irregularities and some of the things he didn't do versus some of the things he probably should have done when he was investigating. And Duke pointed a lot of those things out. He believed that the investigation should have been thorough, but that this wasn't done thoroughly, and that in his opinion, that it was not a well-executed officer-involved shooting investigation. Obviously, this is a defense witness, so it's going to kind of go against everything the state has put up. I do want to remind you people that the state did put up 13 witnesses, and a lot of those witnesses had a lot to say, and some had a lot not to say about the investigation and everything that led up to the moments that Melissa Perez was shot and killed. Now, Goss and Duke would even go on to talk about how he wouldn't have even been able to walk the arrest warrant because he needed more time. That was a really key emphasis on the defense when they were interviewing Detective Soto, was just how much time he took to file an affidavit for charges for Villalobos and Eleazar Alejandro and Alfred Flores. It was a 16-hour investigation. And he said he wouldn't have done it, he wouldn't have felt comfortable doing that if he was a detective on the scene, that there was too much evidence to look at before making that decision. Now, the state and the defense went back and forth. The state did cross-examine Detective Duke, and then there was a break. Another big thing that kind of came out on Friday after that break, and that afternoon break, was the state ended up getting admonished. So what that means, they kind of got a slap on the wrist by Judge Rangel. Apparently, they had sent their investigator in the hallway to kind of see what the conversations were like between Detective Duke and the defense attorneys, which was a big no-no. You can't really hear those conversations. There's a lot of client confidentiality. So it was something that the judge gave into the judge's attention, and he did admonish the state and the investigators for those tactics. Now, again, Melissa Perez, she was 46 when she was shot and killed. It's been, we've seen her family there throughout the trial, and it's obviously been a very emotional trial for them as they've had to hear and see some horrible things that was said, and obviously seeing video of their mother being shot and killed. This is one thing we're going to continue to cover. The live stream is going to start very soon here, with the trials expected to kick off around noon this afternoon. Obviously, it takes a few minutes. It's a little bit of time. We see some of the defendants and some of the attorneys already walking in, getting ready for trial this afternoon. If you want to watch this trial and you want to keep track of it, you got to get away from your TV screen every once in a while and can't sit there for the whole thing. We do have a live rundown of everything that is going on throughout the day. There is a QR code you can scan as well of that rundown. If you go to the live stream article on ksat.com, you can see just how everything is kind of going throughout the day. We have some key updates that we're putting in there. So if you can't sit there and watch it all day, I do encourage though. It's a very interesting trial. It's probably one of the longest ones we've seen here in Bexar County in a very long time as far as high profile cases and how long it's going. As for what's next, I don't know. I feel like there is a lot of unknowns still so far. Now, while the defense has 3 to 5 expected witness, could we see the jury deliberate this week? If that is all possible, I would say that could happen maybe Thursday to Friday, just depending. I mean, we've seen how long questioning has gone and cross-examination and direct questioning of witnesses throughout this entire trial. It's been a very slow process. It is because there are 8 defense attorneys up there all arguing this case and 2 prosecutors. So there's a lot of things going on and a lot of things that we're going to continue to keep our eye on. I believe that the stream is expected to start any moment now. We do have a look inside the courtroom up already. So we're going to go to that live stream. Stay with KSAT 12, ksat.com for all the latest in this case. We're going to keep track of it. We're going to continue to be there with all the information that as soon as it develops, and if it does go to the jury this week, we will have that live for you as well. Always, you can find it on ksat.com, KSAT Plus, KSAT's YouTube page, anywhere where you get our streams. So thank you for joining us today. We'll have more this afternoon on this case.
Welcome back, members of the jury. Hope you had a pleasant weekend. The weather's changed and it's getting dark on us pretty quick. So it's always a good time of the year for me. I always enjoy it. All right, we intend to go through till about 5:15 at the latest today. If you need a break, please let me know. All right, where we last left off, we were in Defense's Cross.
Procedure.
Yes.
Mr. Duke, I have a few questions for you. I'm going to ask a long question, but I'm going to break it down into parts. If I lose you, let me know, okay?
Okay.
All right, so I'm going to ask you, first part of the question, ask if 4 conditions existed, what you would have done. So first part applies to all 4 parts, okay?
Okay.
All right, when each defendant fired each shot that they fired, had you been in their shoes at the moment they fired, would you have reasonably believed, and I'm going to ask 4 different questions, that Melissa Perez was using the hammer as a deadly weapon?
Objective relevance, Your Honor. His belief has no relevance in the jury's decision. It's an objective standard.
Your Honor, if we could respond first, as an expert witness with his experience and with all of his wealth of knowledge and training and everything else, it does become relevant because in this case, any expert's opinion that could help the jury to make a decision, even if it goes to an ultimate issue, is relevant under 704, under 703, under 702. And so as an expert witness, we believe in our clients would like for Detective Duke, retired Detective Duke, to answer that question.
All right, so I'll let the defense rephrase that question.
All right. At the moment that Eleazar Alejandro and first fired, was Melissa Perez using the hammer as a deadly weapon?
Yes.
And when she charged the second time at both Alfred Flores and Nathaniel Villalobos at 2:11 through 2:15, was she using the hammer as a deadly weapon?
Yes.
And when she charged both times, first time she charged was around 2:02:05, and the second time she charged, which was at 2:02:11 or so, was she threatening to use the hammer as a serious, to cause serious bodily injury or death?
Yes.
And was the nature of the threat imminent to one or more of the defendants?
Yes.
And in your reasonable belief, was the firing of the pistol immediately necessary? I haven't finished my question. I haven't finished my question.
All right.
May I finish my question?
Hold on a second. Let me hear the question, and then I'll let the state object.
At the time that each defendant fired, at the time of firing their pistol, was that immediately necessary to stop Melissa Perez's use of deadly force?
Is there an objection to that?
Not if he's not using the word reasonably, Your Honor.
Okay, you can answer.
Yes.
Absolutely. Oh, wait a minute, I'm sorry. Have you reviewed the criminal history which the state has provided to the defense on Melissa Perez?
Yes.
And have you reviewed the reports of Melissa Perez threatening to burn the home of another?
Yes.
And based upon your review of those reports, does that solidify your opinion that the defendants could not have left Melissa Perez in Unit 3102 on June 23rd, 2023 without taking her into custody?
Yeah, I would agree with that.
Pass the witness.
Good afternoon, Mr. Duke.
Hi.
I want to touch on a few things that Mr. Lunan asked you about. There was a lot of discussion last week about on-view arrest versus walking warrant arrest. And there was a statement that, if you remember, was being made that the duty to arrest arose once probable cause is reached. Do you remember that?
I do.
Okay. And so you'd agree there's a difference between someone committing or admitting to a felony in the presence of an officer or on view as being sufficient to support probable cause in that moment, right?
I agree.
As opposed to later on in an investigation developing a belief that someone has committed an offense.
I agree.
So, like when we saw with Melissa Perez when Officer Rojas got there, and we have that felony criminal mischief that she admitted to, right?
Correct.
Remember that? And the on-view probable cause evidence when she committed that felony assault on Jonathan Salinas, right?
Right.
And the on-view probable cause evidence when we see she's committing felony aggravated assault against Nathaniel Villalobos, right?
Right.
And also, another example you'd agree is the on-view probable cause evidence we see when she committed the felony resisting arrest with a deadly weapon that night, right?
Right.
In fact, Mr. Lincoln correctly pointed out several times that, and tell me if you agree, that if a felony is committed in view of a peace officer, an arrest can happen in that moment without a warrant, right?
I agree.
So in this case, if we were to agree with Ronald Soto's opinion that there's clearly a murder committed here by these officers, despite only 2 bullet wounds, it was within view of a dozen other officers, right?
Well, yes, that's correct.
All these officers who saw it firsthand, did you see any evidence that they even contemplated a murder had taken place?
No.
None of the dozen assisting detectives who helped gather statements as a matter of procedure, do you see any evidence that they believed a murder had occurred when they were taking those statements?
No.
Even after these 3 officers sitting behind me had admitted to all the conduct that night.
Agreed.
So that's on view. Talking about the walking warrant scenario, we talked about it being when you later develop an opinion as to that probable cause, right?
Right.
Assuming you have good information, of course.
Correct.
And then I think you testified, tell me if I got this wrong, that you take into consideration the sufficiency of that evidence, the flight risk of the offender, and the danger of that offender to the community.
Correct.
Okay. Mr. Luning kept saying when you have probable cause as though it's this triggering event in time. It's not as though when you hit that low standard of probable cause that you immediately have to go get a warrant, right?
No.
Especially if you're doing that later, after the supposed offense is over.
Correct.
Okay. There's a third alternative that I don't think we've talked about. Are you familiar with the term of filing a case at large or for review?
Yes.
Could you explain to the jury what filing a case at large is as a police officer?
Well, after you've completed your investigation, you put the case together and you forward it to the district attorney's office. You're not making a decision whether the person needs to be arrested or not. You're giving the district attorney the option of deciding what needs to be done, whether they want to take it before a grand jury or if they want to dismiss it. So at that point, the ball's in their court.
And does that allow the district attorney's office, in your experience, to do further investigation if it's warranted?
Yes.
Does it allow them to go back to the filing detective and ask the detective to do further investigation?
Yes.
Have you ever submitted in your career a homicide at large for review by the DA's office?
Yes, many times.
Many times. Have you ever had the DA's office reach out to you after filing a case at large, asking you to do some follow-up investigation?
Yes, many times.
In fact, isn't that typical for officer-involved shooting cases?
Yeah, I wouldn't say it was not typical. I mean, yeah, it's typical.
Of all officer-involved shooting cases, are most of them filed at large, warrants walked, on view? What's your experience with that?
Well, I've never filed a case on an officer, or at every instance that I've had an officer involved shooting, it was very clear that there was no wrongdoing.
And so those cases would still get submitted to the district attorney's office for review, even if that's your belief as a detective, right?
Correct.
And that's to separate the law enforcement out on the street, the detectives, from the DA's office in the decision-making process, right?
Correct.
And that independence is important.
Correct.
Because normally, the DA's office is not part of that walk or warrant situation like we saw in this case. is it?
Right.
In cases where someone may have died, would you agree with me that it's all that much more important to be patient and deliberate in gathering and evaluating the evidence in your investigation?
You've got to be thorough. You can't rush to judgment. You've got to make sure. I mean, everybody involved deserves a thorough, complete investigation,
Everyone, whether you're an officer or just a regular person on the street.
regardless of who. Everyone is entitled to the same.
And that's especially true when everybody at the scene of whatever it is that happened didn't believe in the moment that a crime had occurred, right?
I agree with that.
He can't testify to that, or what everyone at the scene believed.
Sustained.
If these three men were suspected of a crime that morning and were being interrogated and not free to leave, what would a detective have to do to get their statement?
Read Mirandize them, read them their Miranda rights.
Right. Did that happen in this case?
No.
I want to shift gears to another topic that Mr. Luna touched on. Regardless of which of these three ways the case comes to where we are, whether someone's arrested at the time, a warrant's walked, or a case is filed at large, would you agree with me that it's the district attorney's office that makes the decision on whether a case moves forward?
I agree with that.
And it's the prosecutors who decide actually what cases get presented to grand jury at all, right?
Correct.
And they decide what evidence gets presented, right?
Yes.
Both inculpating, evidence pointing to guilt, and exculpating, evidence pointing towards innocence, right?
Correct.
And in your experience, in your many years of law enforcement, would you agree with me that the district attorney's office, who hosts the grand jury and provides them with the coffee and donuts, they have a lot of influence over what a grand jury decides?
I agree.
And the standard at grand jury, is that the same probable cause standard as we have in an arrest warrant, or is it a higher standard?
It's the same.
Mr. Lunan talked about the involvement of the family in cases like this, and he asked about discussing whether to get a warrant on someone and whether you consult with the complainant or next of kin. These cases, let me ask you, they're not the victim, Melissa Perez, versus the defendant, right?
That's right.
It's not Melissa Perez versus Alfred Flores.
Correct.
It's not Melissa Perez versus Eleazar Alejandro, right?
Correct.
And it's not Melissa Perez versus Nathaniel Villalobos, is it?
Correct.
It's the state of Texas versus these officers, right?
Right.
Because and would you agree with me that as victims or next of kin, we can't be in charge of or have any say over our own cases, can we?
No.
We can't be objective.
No.
The government is supposed to be impartial and objective. You agree with me, right?
Yes.
Their duty is to seek justice, right?
Yes.
Now, you've dealt with next of kin many times in your many years working homicides, right?
Yes.
Sometimes you have to break the news to the family that there's just not enough there, right?
Sometimes, yes.
And that's your job as law enforcement to make that decision to tell the family what's going to happen, right?
That's right. It's hard part of the job, but it's part of it.
Even if they disagree with you.
Correct.
So whatever Ronald Soto may have felt about wanting to satisfy Melissa's family after meeting with them, that's not an appropriate basis to rush to go get an arrest warrant, is it?
No, it's not.
And whatever the administration at SAPD or the Civil Rights Division here at the DA's office felt about wanting to satisfy the family, that too would be an inappropriate reason to participate in rushing to get an arrest warrant on these officers.
I agree with that.
Regardless of Ronald Soto's opinion in this case, the standard in this courtroom is not probable cause, right?
Correct.
And I think you said it last week to Mr. Goss, the goal is beyond a reasonable doubt.
Correct.
May I approach, Your Honor?
Yes.
I want to turn back to one of these several demonstratives here. I think it states 184. Do you remember review of this chart with a couple different witnesses? Does this look familiar to you?
Yes.
I think we were covering the round count, and there's some dates on here, right?
Correct.
So you watched Ronald Soto's testimony, and you saw, if you agree with me, that he really dug in about having probable cause 12 hours post-shooting.
Yes.
He was very clear about that that's all he needed, and that's what he had at that moment on that day, right?
Yes.
And that was June 23rd.
Yes.
Okay. So since he walked those warrants for these three officers on that day, with the consent and blessing of the DA's office, the autopsy had already been done, right?
Yes.
We heard testimony about Detective Juarez sharing the findings of that autopsy, right?
Correct.
Which showed 2 bullet wounds, gunshot wounds in Melissa Perez, right?
Correct.
Despite there being 3 murder warrants.
Correct.
Later on, we learned about toxicology coming back on Melissa, right?
We did.
About her extreme level of intoxication, right? But that information didn't provide anything new in terms of the guilt or innocence of these 3 officers, right?
That's correct.
And we heard from Miss Holly Warden about the firearms and tool mark testing, these shell casings and the projectiles. In September of 2023, she did that testing before grand jury in December of 2023. That testing, that didn't reveal anything new about the guilt or innocence of these officers, did it?
No.
Because we knew who shot, right?
Correct.
They admitted as much, right?
Right.
It was documented on dozens of cameras, right?
Right.
And Ms. Warden actually testified that long after grand jury, in September of 2024, there was even more testing done. And I think she said that it was like pulling teeth to get Ronald Soto to go back and get more projectiles out of that apartment. That didn't tell us anything new, right?
That's right.
And the same occasion where he again failed to get a Leica scan. We didn't learn anything new since that first threshold of probable cause that Ronald Soto reached at the beginning.
That's correct.
So if Ronald Soto only had probable cause on June 23rd, 2023, which he said time and time again, and the DA's office was on board at the time, and there's no meaningful investigation that changes anything since that time, what standard are we at?
We're still at probable cause.
And that's without consideration of any exculpatory or justification evidence, right?
Correct.
Ronald Soto ignored the fact that Melissa Perez placed an entire apartment complex of sleeping families in jeopardy. You agree with that, right?
I do.
He ignored putting any meaningful effort into properly investigating that criminal mischief that put all those families in jeopardy, right?
Yes.
And he ignored the fact that Melissa committed felony assault on Officer Salinas. You'd agree with that?
Yes.
And so when Mr. Looning kept asking about her purpose that night, Melissa's purpose that night, asking for your opinion on that, would you agree with me her purpose was assaulting officers that night?
Yes.
Because when someone runs at you with a hammer, it's not to say hello,
No.
it's to hurt you, right?
I agree.
And we know based on Melissa's own statements throughout that night, she was never leaving that apartment willingly, was she?
No, she wasn't.
She was not going to jail no matter what.
That's right.
Further, Ronald Soto ignored the fact that Melissa Perez committed aggravated assault on Officer Salinas by swinging that hammer at him. You'd agree with that?
I agree.
Which is her use of a deadly weapon that could cause serious bodily injury or death, right?
That's right.
And Ronald Soto ignored the fact that Melissa Perez committed an aggravated assault on Officer Villalobos. You agree with that?
I agree.
By her use of, once again, a deadly weapon, right?
Yes.
And all these things she did intentionally and knowingly, didn't she?
Yes.
And not to belabor the point here, but he also ignored the fact that there was a bedridden old man in that apartment who was defenseless against whatever it was that Melissa might do that night.
I agree.
So after all of that, all we have is Ronald Soto's version of probable cause, right?
I agree with that.
Based on statements taken as a matter of standard procedure, because unfortunately, we see officer-involved shootings happen that aren't criminal at all. Right?
Correct, yes.
Because sometimes officers have to do what they have to do, right?
Yes.
They have to assert that right to go home, right?
Yes.
To go see their wives, right?
Yes.
Go see their kids. Right?
Correct.
And continue serving their community.
Correct.
So Ronald Soto's probable cause is the same evidence in 2023 as what we have now, right?
I agree with that, yes.
And I'm sure you remember Detective Soto's testimony about the foundation of his belief that day and why he walked those warrants. It was because Melissa Perez was back in the hallway, right?
Yes, that's
And so
right.
we learned that for the first time in 845 days, we saw it in real time. Detective Soto learned that she wasn't just 1 or 2 or 3 or 5, 4 or 5. She was 6 steps closer, within just feet of Alfred Flores that night, right?
I agree with that.
And that was the foundation of his getting those arrest warrants.
That's right.
I think, Mr. Diggs, that's all I have, Your Honor. Your Honor, we don't have any regret.
All right.
No question.
All right. Thank you.
Thank you.
All right, defense?
The defense calls retired Detective Lisa Miller, please. Sergeant, sorry, Ms. Miller. Sorry.
Have a seat. I'm going to swear you in.
Yes, sir.
Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
You may need to adjust the microphone, make sure everybody can hear you. You can introduce yourself to the jury and spell your name for the court reporter, please.
Good afternoon. My name is Lisa, Lisa Miller, Miller.
Defense?
Thank you, Judge. I'm sorry, Sergeant. Sorry about that. So now that you introduced yourself to the jury, what did you do as a profession before you retired?
I was a police officer for San Antonio Police Department for 28 years.
And just kind of give an overview, how did you serve in that role over those years?
I had a fantastic career. I spent 11 years on patrol on the Deep West Side, and like Detective Duke, I was a field training officer. Spent the majority of that 11 years working the 2 to 10 shift in the afternoon and at night. And when I promoted to detective, I was assigned to SVU. I was there for 4 years. We handled crimes against children, family violence, and all felony sex crimes. While I was with SVU, I was appointed as an instructor out at the police academy. And I taught a couple of different courses because I was a state certified special investigator of family violence and sexual assault. After the 4 years in SVU, I moved to homicide, to the murder detail. I worked both cold case and active murders. And I continued working as an instructor for the academy. I created and taught a 40-hour course for all new detectives who were recently promoted to teach them how to do criminal investigations. The last year I was assigned to homicide, I was on loan to the U.S. Marshals as part of their Lone Star Fugitive Task Force. And then I was promoted to sergeant. I went back to patrol on the Deep West Side and spent a little over 5 years there before I retired.
Yeah, that's a long career. And I want to break down, that's kind of the overview. I want to kind of break down some of those individually. So give us, we have to ask this question, you know that, Sergeant. Some of your training and background, academy, some of the things you did to become a patrolwoman.
To become a patrol...
Yeah, just to become a police officer.
Oh, in the academy. Yeah, the foundational education you get in the academy, it was 6 months long when I was there. I think it's now up to 7 or 8 months long. But you're taught traffic code, alcoholic beverage code, health and safety code, family code, penal code, the code of criminal procedures, the San Antonio Police Department's general manual. You're taught tactics. The physical aspect of the academy is unbelievable. If you guys ever get a chance to do the Civilian Police Academy, I don't even know if they're still doing that, but I would strongly suggest it if you want an eye-opening experience to what it's like to be in the police academy.
And so then, at some point, you had your field training officer, you were on probation, and then you went on patrol for those 11 years, correct?
Yes.
Okay. And then you think you stated to the jury that you promoted to detective?
I did.
And you used an acronym, SVU. I know what that means. Will you tell the jury what that means?
It's a Special Victims Unit.
And what did you investigate when you were a detective for the Special Victims Unit?
I started out working because that unit is divided into two separate parts. It's divided into the sex crimes part and the family violence part. I worked in both of those sections, and both of those sections deal with family violence, crimes against children, and all felony sex crimes.
On average, I know you don't have the stats in front of you, how many cases do you think you handle a month?
Oh, that unit is understaffed and overworked. It was common, probably for every felony investigator to be assigned at least 20 cases a month.
Now, did you tell the jury that serving in your time as a detective for the SVU unit, that you ended up teaching at the academy as well?
I did. I taught 2 courses while I was in SVU. One was intermediate child abuse for patrolmen who were trying to upgrade their certifications, because there's 4 levels of certification as a peace officer. You start out basic, and then there's intermediate, and then there's advanced, and then there's master peace officer, and that's the certification I held when I retired. Intermediate child abuse is a mandatory course that they have to take so they can get upgraded in their certification. And then I taught senior leadership and newly promoted sergeants the special victims, sexual assault and family violence course to bring them up to date on the current laws.
Now, you ended up writing the curriculum for some of these courses, correct?
I wrote the curriculum for all of those courses, yes.
Sorry about that. Now, at some point you were transferred from SVU to homicide.
Correct.
And then how long were you in homicide? I know you mentioned it, but I want to break that down. How long were you in homicide?
7 years, but 6 years on the murder detail, and then 1 year with the U.S. Marshals Service.
So is it fair to say that that 8th year or that last year with U.S. Marshals, you weren't doing as many homicide investigations at that time?
That's correct.
But tell the jury, not me, tell the jury kind of your duties as a homicide investigator.
So when you're on the murder detail, you're not just investigating murders. You're also investigating suspicious deaths, accidental deaths, except for vehicle crimes. If it's a DWI assault or DWI manslaughter, we have a special traffic unit that does the traffic investigations. The murder detail doesn't deal with the aggravated assaults or the simple assaults. There's two murder teams, and that way we cover all 7 days of the week. So you could get 3 or 4 or 5 calls a month that are not murders, but you still have to go out and investigate them.
Now, I believe that at that point, did you end up again serving SAPD by teaching or writing curriculum for homicide detectives?
Not just homicide detectives, but for all newly promoted detectives.
So what was that curriculum? What did it look like specifically for the homicide? Well, let's do one thing at a time. Let's do the new detectives first.
Okay.
So what is a criminal investigation? Just in general, because whether you are an investigator for SVU, or if there's an investigator for property crimes or for homicides, there needs to be a framework of what a criminal investigation is. Can you please explain that to the jury?
So a criminal investigation is a legal search for people, witnesses, or things, evidence that can be used to help you recreate an incident that may be criminal and the mental state that accompanies that criminal activity. It is a patient and thorough and thoughtful exercise working backward in time from the known to the unknown, and the goal of it is to find the truth. The thing that's frustrating about that is because finding that truth depends on what your witnesses are willing to tell you and what the evidence can show you.
So I guess, I'm assuming, well, I know, but for their sake, most homicide investigations, it's hard to find witnesses. Is that a fair statement?
You would be surprised, but people lie to the police from time to time. So it makes investigating homicides very difficult.
And at some point, we're going to bring your attention to this investigation by Detective Soto, because that's not what we had here. We had a lot of witnesses and people willing to talk. Is that a fair statement overall?
Yes.
Okay. So that's a general now. So as a homicide investigator, you did that for 7 years. How many homicides over those 7 years do you think you investigated?
If I had to guess, I'd say somewhere around 80.
Roughly, give or take?
Give or take.
Okay. And you mentioned cold cases. Is that the time that you investigated cold case murders as well?
No, I don't even count that.
Okay. At what point did you get into that type of investigation?
That was the few months right before I went over to the Marshal Service.
And what is, just so we don't leave this hanging for the jury, what is considered a cold case?
There's not a specific time frame that you reach that you say, okay, now the case is cold, because you can have a detective who spent, say, 10 years in homicide, and he may have on his desk one of the first cases that he ever got, but he just can't turn loose of it. So it's kind of depends on the individual. A lot of cases become cold because a detective will transfer out or get promoted, and then those cases will go into the cold case file. So there's a lot of variables that determine when a case is cold and when it's not.
And did you have occasion in your career to solve cold cases?
I did.
So now I want to bring your attention to you being a sergeant. After you served not only our community but SAPD as a homicide detective, at some point I think you told the jury that you promoted?
I did.
What entails promotion? Do you get chosen? Is it just a merit system, or did you have to take an exam?
For both the rank and of detective and sergeant, it's based solely on your test score when you take the promotional exam.
So now I want to bring your attention now to this investigation. Did you have an opportunity to review this investigation that we heard? The investigation involving Sergeant Flores, Officer Alejandro, and Officer Villalobos?
I did.
Roughly, I know you're not doing billable hours, and we'll talk about with your compensation or not, but how many hours roughly do you think you have spent reviewing this case?
Hundreds of hours.
Hundreds meaning more than 100?
Yes.
200 and more, okay. Now let's talk about, have you been compensated for this?
I've been compensated for the work I have done up until this year.
So there's been a period of time where you haven't gotten any compensation?
Correct.
Who has compensated you?
Combined Law Enforcement of Texas, the statewide police union, is paying my salary.
Did you charge your normal rates for this?
No, I did not.
Are you keeping track of every hour or minute that you're spending on this case?
No, I am not.
Have you been sitting in this courtroom all 3 weeks of this trial?
Yes, I have.
And that is normal for an expert to do before they testify?
Objection to leading, Judge.
Also stand.
Do you know if that's normal?
Yes, it is normal.
I guess in general, do you have an opinion on how this investigation was handled?
Yes, I do.
May I ask you what that opinion is?
Looking at the totality of the circumstances of this case and the paperwork that was generated by Detective Soto, I believe this investigation was corrupted by the insertion of a bias, making a decision too early in the investigation without examining all of the evidence before a conclusion was reached.
So let's talk about, you mentioned the word bias and you corrupt, and you're not talking about someone was paid off corrupt, you just mean defective. Is that a fair statement?
Objection to leading again,
I'm just
Judge.
trying to clear it up. I'm really trying to clear up this situation, Judge. Okay, thank you, Judge. I mean, so you don't mean corrupt as in someone's getting paid off?
No.
Okay. But I want to talk about why you think it was corrupted. You mentioned bias. Are there pitfalls to an investigation?
Yes, there are actually 3 major pitfalls that a good investigator needs to be aware of and try to avoid. The first of those is your emotions. Especially in homicide investigations, it's disturbing to go to a crime scene. It can upset you to go to a crime scene. Some of them are gruesome. Some of them are heartbreaking. You have to leave your emotion at the door when you get back to the office to start working on your investigation. That's the first one. The second one that takes a lot of self-reflection, and you have to be honest with yourself, is you have to avoid any personal or professional biases that you may have. And they can be things that you're not even aware of, and I'll give you this as an example. I was investigating a murder case and my suspect was in jail on an unrelated charge, and I said to the office, "Hey guys, I'm going to run over to the jail and try to talk to this guy." And everybody started laughing and they said, "That's a hardcore gangbanger. Why are you going to waste your time going over there and talking to him? He's not going to tell you anything." Well, that's a professional bias. If you've already decided who this guy is, none of you know him, but you've already made a decision about him, that's a professional bias, and you have to be aware of those. The third thing, and this is what Sherlock Holmes describes as the bane of investigations, is to, instead of forming a theory or a hypothesis about what possibly happened and working until you're left with what probably happened, you jump to a conclusion before you have gathered and analyzed all of your evidence. That is probably the worst mistake an investigator can make, and I believe it's the one that Detective Soto made in this case.
So what's the overall objective? I mean, if you could boil it down, what's the objective of a detective when they're investigating a murder scene? A murder allegation or some type of murder allegation or scene, when you think it's a murder scene, you're trying to get to the bottom of that. What's your overall objective?
It's to find the truth.
So, directly, you were in court when Detective Soto testified?
I was.
I want to ask you about something. He testified before this jury that when he walked onto the scene, he said when he walked onto the scene, he said I have concerns. Did you hear him say that?
I did.
Do you have an opinion of him saying that, and should he have said it, or what that would mean, and how would that affect maybe his investigation moving forward?
I think Detective Soto has a remarkable ability to jump to conclusions. He forms opinions of things too early in his investigation. Seeing a pile of shell casings should not be a concern to a detective who's just arrived upon the scene, because I can come up with several scenarios as to why that pile of shell casings would make perfect sense.
So, do you have an opinion on whether you think that maybe tainted the way he looked at the evidence moving forward?
I don't want to say he had a preconceived idea of what happened at this call, but I can tell you that his ideas were premature as he arrived at the scene to start investigating.
Okay, so you're very intimate with this incident. How many, the jury knows this, but how many officers were there?
In total,
Yes, ma'am.
15.
What are they potential? Those officers are potential what for a jury like this?
They're all witnesses, some of them actors.
Do you recall, have you kept track of how many of those witnesses the government has brought for this jury to listen to?
I only recall 2.
Officer Rojas,
Yes.
Officer Ramos.
No.
Not Officer Ramos, I'm sorry. Maybe I wanted to hear from him. Officer Chernak,
Yes.
and then Salinas.
Oh, yes.
Those 3, okay.
Yeah, 3.
What witnesses would you, if you were the detective, in analyzing this investigation, would you have wanted to speak to in trying to investigate the truth of this incident?
I think the first witness I would have tried to contact was the 911 caller who called the police that night and gave the description of Miss Perez. She was an eyewitness to some of the behaviors that were happening, and I was a little disappointed to see that she was never contacted in the investigation.
How about the officers in front of the incident? Now, obviously, we've seen the body cam, but the officers in front of it, would it have been important for a detective to talk to them and find out what they were thinking at the same time as the 3 officers behind me?
Yeah, so reviewing the videos, I identified a total of 7 officers, and there may be more, but I identified 7 officers who at one time or another drew their weapons and pointed them at Miss Perez. 3 of those officers fired. The other 4 did not, and I was very curious as to why they did not. So I contacted 3 of them and had conversations with them about that. Detective Soto did not bring those other officers. I don't even know if he realizes how many officers drew their weapons during the course of that whole scene.
Are you aware that when an expert testifies, they can rely on hearsay?
I am.
Okay, so I want to talk to you about these conversations you had with these officers. Who did you contact first?
Maria Salinas.
Will you please describe to this jury your conversation with Ms. Salinas?
There were 2 times during the incidents where Officer Salinas drew her weapon. One was when Officer Villalobos was alone on the patio. She drew her weapon, and she drew her weapon again during the actual shooting, although she didn't fire either time. I asked her why that was, and she said, I would have fired, but there were officers in front of me, and I knew it was not safe for me to do so.
And that's good training, right? Because you have to know what's in front of your target. Obviously, it would not have been safe for Officer Salinas to shoot because there was officers in front of her, correct?
Correct.
Okay. Who's the second officer that you spoke to?
Travis Thompson.
Will you please share with this jury what your conversation with Officer Thompson was like?
We went over his general thoughts about the entire circumstances that led up to the shooting. He said he did draw his gun, and the reason he did not fire is because he lost sight of Miss Perez as she moved to the back of the apartment.
And who's the third officer that you spoke with?
That was Officer Ramos.
Will you please share your conversation with Officer Ramos?
Officer Ramos said he drew his weapon when Officer Salinas was on the patio and being struck with the candle, but he said he honestly does not know why he did not shoot.
Is it important for a detective in an investigation like this to consider Chapter 9 of the Penal Code?
Absolutely.
In general, can you describe, they've heard some of it, but what Chapter 9 references?
Chapter 9 provides the justification for what would otherwise be illegal activity. It tells you when you are legally allowed to protect yourself, when you're legally allowed to protect a third party, and when you're legally allowed to protect your property both by using physical force and by using deadly force.
Is it important for a detective to consider those justifications when you're making a determination of whether to charge someone with murder?
Yes, it's not just murder cases where you have to take justifications into consideration. Anytime you're investigating any crime, there's all kinds of caveats written into the law. We can call them an affirmative defense or a defense to prosecution or an exclusion to prosecution or a justification for the activity. At the end of your investigation, you need to research the laws to make sure there's not some legal reason that we would not prosecute someone over that behavior that would otherwise be criminal.
Can I push, Judge?
Yes.
Is that blue gun? Are you aware that this is a fake gun? It's a training gun, correct?
Yes,
You can tell, you can tell that the slide does not move, the barrel is not real, and the trigger does not move, correct?
Yes.
Okay. I won't point it at you, I'm gonna point it to your right, in between you and Mr. Hernandez, and above our court reporter. Let me do this, I'm sorry, just have it. If I point the weapon at somebody, what would that normally be?
it would either be aggravated assault or deadly conduct.
Assault with a deadly weapon specifically.
Yes,
That would be a second-degree felony.
yes,
And so that is illegal behavior if there's not a justification for me to point this weapon at somebody. Is that a fair statement?
that's correct.
If I feel threatened by that hammer, and then I point this weapon at you, it's no longer, what is it? Is it still an assault with a deadly weapon?
No,
Why?
because Chapter 9 says that you have the right to protect yourself from unlawful deadly force.
Now, if that was a knife that you had, or you were coming at me with a car, would it be the same scenario?
Same thing,
If you had a firearm, would it be the same scenario?
same thing.
So as you stated, better than I did, Chapter 9 are justifications for other activity that would normally be illegal, but then it's justified, not an excuse, it's justified because of the specific circumstances.
Correct.
And does Chapter 9, how does Chapter 9 guide us and instruct us on whose eyes we should be looking through?
Chapter 9 specifically tells you that it is the eyes of the beholder, the person who is involved in the use of force. Not what some bystander believes, but what the person who's actually using the force believes.
May I approach again, Judge?
Yes.
So in our scenario, I'm going to give you the hammer again. If I'm going to stand here near the jury. So what Chapter 9 says is for us to hand the glasses of the actor to the jury or to the evaluator, for them to look at the situation through my eyes holding the weapon. Is that a fair
Correct.
statement?
Yes,
And should those same glasses, Chapter 9, we'll call them Chapter 9 glasses, should those Chapter 9 glasses be handed to Officer Villalobos, Officer Alejandro, and Sergeant Flores
yes,
under this circumstance? This
yes,
analysis. Before we move forward, I want to go back to Maria Salinas, because there was some back and forth that occurred about what she said in her statement, whether she could testify, and what she saw on the first swing. You remember that?
yes,
Judge, may I put you in there? So before the three officers behind us discharged their weapon at the same time, did you see Officer Villalobos try to reach into the apartment?
yes.
What was he trying to do?
To unlock the patio door.
Do you have an opinion on whether that was part of a bigger plan to apprehend Ms. Perez?
I don't know if it was part of the plan at the time, but I know he was trying to create a way to get into the apartment.
And you recall that ordeal where Melissa Perez came at him with a hammer and he had to move back.
Yes,
Did officers draw their weapon during that engagement or that exchange?
yes.
Do you remember which officers drew their weapons?
I only remember Maria drawing hers. I think there were a couple of tasers, but I don't remember who had them.
May I return the hammer, Judge?
Yes.
when you talked to Maria Salinas, did she talk to you about how close, because we saw the video and there was some back and forth on whether she was saying, hey dude, she was that close to you, and then you remember the government making a big deal about, well, we can't see it from the body cam.
Right.
Objection is the hearsay, Judge.
I was talking about what they said, Judge. It was in court.
All right, let me hear the question.
Did Maria Salinas tell you during that engage how close that first movement towards Officer Villalobos was before the shooting?
She didn't.
Objection, hearsay.
She's an expert, Judge. She's been testifying in Maria Salinas' conversation with her for minutes now. Now he's objecting?
Oh,
Continue, sir.
I didn't speak to her specifically about how close the hammer came to Officer Villalobos, but she did mention that she came close to pulling the trigger at that time.
Objection is to strike and is non-responsive to the question.
I'll sustain.
Okay, so Sergeant, did you have a conversation on whether she got close to discharging her weapon during the first attack from Ms. Perez?
Yes.
Objection, relevance.
It's relevant, Judge. It goes to their behavior that night and what threat they were facing, and this is the first threat.
It's, again, how close Maria Salinas came is not relevant.
Overruled.
Continue, sir.
I'm sorry, what was the question?
Did she talk to you about how close she came to discharging her weapon from that first engagement from Ms. Perez?
Yes, that was her comment to me, as I came close to pulling the trigger when she first attacked V.
And V is who?
Officer Villalobos.
Got it. So, I want to direct your attention now to the timeline of this investigation. You saw how fast it was, how fast the determination was made to walk warrants. You've seen that during this trial?
Yes.
And that we're going to debate whether it was, the decision was made in 8 hours and then they walked the warrant in 14, but let's just give 16 hours. Is that normal to walk a warrant in 16 hours in an officer-involved shooting like this?
No.
Can you, from your experience, can you tell us what the normal timeline of an investigation on an officer-involved shooting would be and take, and how it would go through the process?
Yeah, I can't give that to you in hours, but I can give that to you in a description of what needs to happen in an investigation. Remember, I told you that it was patient and thorough and thoughtful. And what you're doing in that time is you're gathering all of your evidence, your witness statements and your physical evidence, and you're evaluating it. You have to evaluate what your evidence is showing you, and you have to analyze what the evidence is showing you. So that's very time consuming, because it's not just that you got a statement or one of the other detectives runs over and tells you, hey, this is what the witness said. You actually have to take the time to digest that information and put it all into perspective. There was no way in that timeline that he even could evaluate all the evidence. In fact, we know he did not from the audit trails of the body-worn cameras. I totaled up, just in raw numbers, there was over 18 hours just of video from the officers' body cameras.
Well, that's what I was going to go with you next, and so we won't belabor the issue. I think the jury has had their fill of audit trails, but it's important, right? It is critical because it gives us evidence of what was done or not done. Is that a fair statement?
Yes.
Okay, so you mentioned 18 hours of data, of information or video. Is it normal for a detective not to view all evidence, to include body worn, if you have actual video, before they make an allegation and walk a warrant for something as serious as murder?
I don't think you can.
So, I want to talk, Mr. Newman went over with Detective Duke, but the duty to arrest Melissa Perez versus Detective Soto's duty to arrest. Do you remember when there was an exchange with the government and asking questions about that?
I do.
Okay. Can you make that distinction? I think Detective Duke addressed it, but could you Do you have an opinion about those two things?
Yes, I do. The Code of Criminal Procedures in Chapter 2A specifically tells officers that in all instances where they have the authority to arrest without a warrant, they are to arrest. It says the officer shall. It's not giving them the option. It's telling them if you have a warrantless arrest authority, you need to act. But there's nothing in that chapter that directs an investigator to immediately obtain an arrest warrant and go out and arrest people. Those are two different standards, and there are reasons why an investigator should not immediately go out and get an arrest warrant.
Now, when it comes to the situation where Melissa Perez had committed those multiple felonies, to include aggravated assault against public servants, right?
Yes,
And having that older gentleman there that was obviously bedridden,
yes.
was there any scenario where any officer, under their training and through your experience, would have left Melissa Perez at the apartment at that moment?
No, I don't believe so. In speaking with some of the other officers, I would ask them this question: would you leave an infant with Miss Perez? And of course the answer would be absolutely not. And that's because there are groups in our society that receive special attention from our legislatures. They've made laws up specifically for them, and that is the elderly, the very young, and the disabled. And so police officers feel a special protectiveness over those classes of people because the legislature has told us they need special protection.
Now that's one aspect of it, but then would there ever be a scenario in your training and experience where officers would just leave a suspect alone after they've allegedly committed multiple aggravated assaults against peace officers?
Never.
So when we talk about that incident, you said there was 15 officers there. How many other sergeants were there?
There were a total of 3 sergeants there.
It was Sergeant Flores,
Yes,
Sergeant Rivera, and
yes,
Sergeant Robertson, correct?
yes.
Okay. Now, in your evaluation of this incident, did you come to find out whether any of the officers or any of the sergeants disagreed with what was happening at that moment on the plan to apprehend Ms. Perez?
No.
Did you feel in your investigation that Sergeant Flores, Officer Alejandro, or Officer Villalobos were acting rogue and against the orders of some higher authority?
No.
You mentioned something earlier, so I want to make sure we clear it up because it caught my attention. You talked about premature conclusions. We heard this, but what number of officer-involved shooting investigations was this for Detective Soto?
This was his first one.
We heard about the rotation. In your experience, should he have investigated this being his first officer-involved shooting?
No, not just because he didn't have the experience, but he also did not have the training to conduct an officer involved. He didn't have any training in specifically in homicide investigations. So it would have been wise for his supervisors to assign this case particularly to a seasoned detective and have Detective Soto shadow that detective who was actually conducting the investigation.
In the course of your reviewing this incident and this investigation, did you come to find out of a meeting with Captain Van Geffen?
Yes, Captain Van Geffen wrote a report about that meeting.
Did you review that report?
It was only a couple of lines, yes.
Did you come to find out whether Captain Van Geffen met with certain people about this incident?
Yes.
Who did Captain Van Geffen meet with?
His report stated that he met with Mr. Harris.
Do you know when that happened?
The day of the shooting, later in the afternoon.
So the day of the shooting later in the afternoon, within that 16 hours, right?
Yes, sir.
Captain Van Geffen met with Mr. Darrell Harris sitting at the government's table here.
That's what his report reflected, yes.
Did the report reflect what they talked about?
The report said They discussed the case and the decision was made to arrest.
Okay, I want to talk about that. So what you're telling this jury, based off Captain Van Geffen's report, that Captain Van Geffen met with this gentleman to my left, Daryl Harris, and the discussion in that meeting was made to make the arrest.
That's what the report reflected.
So is it fair to say that Mr. Harris was involved in that decision to make this arrest?
I can't reach that conclusion, but it conflicts with Detective Soto saying he made the decision to arrest.
So we heard Detective Soto tell this jury that he made the decision to make this arrest, correct?
Yes,
And so there's once again some inconsistencies.
yes.
Can you make any conclusions from that, or do you have an opinion about that?
I still don't know who made the final decision to arrest these officers.
Did we hear from Captain Van Geffen during this trial from the government's case in chief?
No, sir.
Do you know why?
No, sir.
Can you tell us, because is that normal for the DA's office to be on the front end of an investigation?
Not when I was assigned to homicide, it wasn't.
Is it fair to say that the DA's office is a reviewing agency, not an initiating agency?
That was my experience
Can you
with them.
explain what an initiating agency is to this jury versus a reviewing agency?
The initiating agency would be the Bexar County Sheriff's Department or the San Antonio Police Department or Balcones Heights Police Department, anyone within Bexar County that is the investigating agency of an incident. And then we would take it, they have an input section at the DA's office. You take your case file and give it to intake and they review it and they decide whether to accept the case or reject the case, or sometimes they accept it with a but I need you to do these things before we'll move forward with the prosecution of it.
Do you have an opinion on what that does to an investigation when the DA's office is front-ended, they become initiating portion, they serve in that role?
I think there has to be a division between those two agencies so that the DA's office is able to maintain its neutrality and not be influenced by what the detectives think or what the police are doing.
Is it possible, since now we have evidence, we have a report that says that the DA's office, specifically Mr. Harris, was in a meeting with Captain Van Geffen, could it have been possible for the DA's office to have reviewed all this evidence before the decision to arrest these three men behind me?
Oh, absolutely not.
So you're saying that the DA's office couldn't have reviewed this evidence, nor could any of the detectives?
No, because the ballistic evidence had not even gone to the crime lab yet. The autopsy had not even been performed with the results back from that. There was so much evidence that was available to be analyzed and nobody analyzed it.
I want to direct your attention to the prosecution guide of Detective Soto.
Oh.
Well, you made a noise.
I'm
Well,
sorry.
why did you make that noise?
I'm hard pressed to call it a prosecution guide.
Okay, well, first of all, what is a prosecution guide? And then I want to go back to why you made that noise. What is a prosecution guide?
A prosecution guide should be a road map that the detective writes describing all the steps of the investigation, the things that were done, the people who were excluded as suspects, what the evidence shows, how it was applied to the investigation. Anybody should be able to pick that prosecution guide up and read it almost like a storybook that will take you from the beginning of the story to the conclusion at the end of the story.
Should a prosecution guide consider self-defense and defense of third person in its analysis?
Absolutely, especially when the people that you're looking at are claiming self-defense.
So you made a distinction. You might not look at self-defense on your own as a detective, but when someone is claiming self-defense and defense of third person, you should explore that thoroughly. Is that a fair statement?
You have to explore that thoroughly.
So now I want to go back to why you made that noise. So what about that prosecution guide in your review of it do you obviously disagree with?
Remember, I told you that I thought the investigation was tainted. I'll use that, a better word than corrupt, but I found the evidence of my thoughts because the entire prosecution guide is full of confirmation bias, where important information about the things that Ms. Perez did were mischaracterized or completely omitted from the official records. I can point out to you page after page after page of confirmation bias that appeared to me that a conclusion was reached, the decision was made to arrest the officers, and all Detective Soto looked for from that point forward were the things that shored up or confirmed his conclusion.
Let me ask it this way. If you had been in the position of any of the three officers behind me, and based off of your analysis in this case, I'm going to ask what you would have done. Would you have believed it would have been reasonable and immediately necessary to stop Ms. Perez with deadly force?
Yes.
Pass it, Mr.
I'm wondering if he might... We might take a break.
All right. Members of the jury, let's take a short break. We'll let you know when we're ready.
All right, the jury.
May be seated? Yes, ma'am. No, yes, ma'am. So.
stop in New Jersey because I'm going for my legs. My parents. Upstate. I'm going for my New Jersey. My oldest is 16. He's the same as me. Much as I'm going back to Texas, keep that Jeopardy, Alex Trebek. Used to go out and he's supposed yeah, they're all, like I said, they're all programs that are in there. You gotta do so many hours. He works at Fox 5. Yeah, he's radio.
Oh. Yeah. You got live.
You don't have a hair. You don't
Every other person. Oh, no. 6 a.m.
You guys aren't bad. We learned from
You have a court officially? You officially have a court?
This one.
All right, members of the jury, welcome back. Defense?
I believe it's the pass.
Of state.
Yes, sir.
Sorry about that.
And, Sergeant Miller, good afternoon to you.
Thank you, and to you too.
And I recall we probably met our paths crossed back when you were the special instructor, senior instructor in sex crimes and domestic violence.
That is correct. And you, sir, were a baby prosecutor at that time.
It's been a long time since. Thank you, ma'am. So, I'd like to go through and my review of your testimony. You indicated that you would like to have talked to the initial 911 caller. IDR lists her as Mary Ann. Now, you'd agree with me, the initial 911 call was made at about 11:32 on the 22nd, correct?
Yes, sir.
And that ultimately, our ultimate conclusion, shots are fired at or about 02:02 hours on the 23rd, correct?
Yes, sir.
And so that 2.5 hours time, we're here not because of the criminal mischief state jail level or misdemeanor to the fire alarm. We're here because of the officer involved shooting, the death of Melissa Perez. That is the locus, correct?
The reason that we are here today, yes, sir.
Okay, and I'm not aware, and maybe your review turns something else, I'm not aware that Mary Ann or any civilian has been listed as an eyewitness to the shooting. She was not, to your knowledge, correct?
No, sir.
Okay, so, and again, we don't know until we actually talk, but reasonably, you don't really expect Mary Ann, the caller for the criminal mischief, would have additional information about the officer-involved shooting, do you? That would be a yes or no question.
Yes, sir, I do believe
Okay.
she had additional information.
Okay, and what would be the additional information to inform the trier of fact about the officer-involved shooting if she's not a witness to it?
Well, I'm not necessarily looking so far ahead that I'm in court when I'm doing my investigations,
Yes, ma'am.
but listening to the 911 tape, I would like to correct you on one thing though, sir. It wasn't just a criminal mischief. It was actually a burglary of a building that the officers should have recognized when they first got there. So that was a felony. It was always a felony. They just didn't recognize what they had. When she went into that little storeroom, that's a burglary of a building. So I just want to start with that. But listening to the 911 tape, am I allowed to talk about what's on the 911 tape? I'm not sure.
Well, hearsay rules are still in effect, but if there are observations you made.
At the end of the 911 call, and Mary Ann, if that was her name, was on the line for quite a while with the 911 clerk. And at the very end of the call, the 911 clerk says, we'll call back if anything changes, if she becomes violent. And the witness says, yes, she has a tool in her hand and she's being violent. So I think that was something that needed to be explored. What was Miss Perez's continence at the time that the 911 caller called? Maybe not important to your case here today, but definitely important to me as an investigator.
All righty, ma'am. But again, you're here and testifying for this case, correct?
Yes, sir.
All righty, ma'am. And let's see. You then spoke that there were approximately 15 officer witnesses and they were all willing to talk to you, correct?
I don't know if all 15 were willing to talk to me. No, sir. I said I contacted 3 of the 4 officers who also drew their guns but did not fire.
All righty. And I'm may have misstated your notes. You wrote, "This case had a lot of willing witnesses." That was the statement you made on direct, correct?
I think I made that statement, Judge, just for clarification.
Yes, sir.
I apologize.
He made the statement, and I did agree with it.
Okay, so you adopted his statement. That's where I got from my notes. Thank
Yes,
you.
sir.
So you spoke about talking to Officer Maria Salinas, who drew her weapon 2 times. You remember saying that to the jury?
Yes, sir.
Now, the first time she drew, that was when Officer Villalobos was in the patio himself, correct?
Yes, sir.
And she was one of those that yelled, "Hey, hey, hey," and then he quickly backed up. You recall that?
Yes, sir.
And you told this jury that she said she didn't fire because we had an officer downrange, correct?
No, sir. That was the second attack of Villalobos and Sergeant Flores.
But he was downrange of her at the time, wasn't he? The first time when Villalobos was in the patio, he was downrange from her weapon, wasn't he, ma'am?
Oh, yes. Yes,
Okay.
it was.
And she also observed him propping his left foot up against the door because it opened out such that Melissa Perez couldn't get out to him, correct?
I didn't discuss that with her.
She didn't discuss that, but you've seen the body cam, correct?
Yes, sir.
You've seen her body cam, which shows Villalobos, if I may I stand, Judge?
Yeah.
Standing outside the door, he's got his left foot out. He initially draws his weapon, then he transitions to less lethal with his taser. You remember that sequence?
On the first attack,
The first time he jumped over, yes, ma'am.
I don't recall him pulling his taser out on that occasion. I mean, it may have happened. I don't recall that.
Okay, let's, as they say, go to the tape. And for the record, Your Honor, I'm going to State's Exhibit 10, the body-worn camera footage of Officer Maria Salinas.
Okay.
Judge, this screen is not working right
Got it?
Thank you.
If you're asking me to go there, you're asking the wrong.
Thank you. You know what? It's my Thank you, Josh.
Apologize, Your Honor, I'm trying to recall when it occurred. 1:51, thank you, sir. We are proceeding at approximately 01:50:29. Okay, and so I apologize, I misstated. It's not his left foot, he's actually has his right foot bracing the door, and he moves from lethal to his taser less lethal, correct? This is his right hand?
I never saw him draw his weapon, so he went to less lethal, while Officer Salinas had lethal.
Okay, maybe my memory is faulty. I'll play it back at slow speed.
She's coming. Hey, watch out, baby. Hey! Get her
Okay, yeah.
And so his initial reaction, he drew lethal, and then he's got backup behind him, he goes to less lethal.
Correct.
That's general guidelines, less lethal, lethal, they work together, correct?
Yes, sir.
And you'd agree with me that from her vantage point, we can't see everything with the eyes reflect, we've heard that, but she has a friendly force, downrange, that would be an unnecessary risk, wouldn't it?
I think that would have to be a judgment call. Would I be comfortable shooting?
Well,
probably not.
All right, and we know that Officer Maria Salinas did not fire at that occasion. So
Correct.
The evidence might support she made that same judgment call. Wouldn't you agree?
Yes.
Okay. And then we all know the second occasion after the execution of the plan, correct?
Yes.
And in that case, Officer Maria Salinas, she was not at the front closest to the rail, she was behind Officer Alejandro, correct?
Yes, sir.
And so she would be shooting over him, past Sergeant Flores, along with past Officer Villalobos, correct?
Correct.
And Defendant Alejandro, he still has those first two. He made a different decision, didn't he?
Yes, he did.
Okay. You then said that you talked with Officer Thompson, who drew his weapon, but he lost sight. He didn't fire because he lost sight of Melissa Perez, correct?
Yes, sir.
Now, and then Officer Ramos, you said you spoke to him, and he admitted to drawing his weapon, but he also didn't fire. He couldn't tell you why.
Correct.
Now, do you remember how Officer Ramos was positioned? Wasn't Officer Salinas downrange from him when he stood outside the rail?
Yes, yes, sir.
Okay, and I recall that even though Officer Jonathan Salinas first drew his service weapon, he downgraded it to less than lethal after he was hit by the glass. Do you recall that?
Yes, sir.
That would indicate that he didn't believe throwing the glass, it is a crime, assault on a public servant, but he didn't consider the glass being thrown as deadly force by his own actions. You'd agree with that, correct?
Yes, sir.
Okay. And you interviewed or talked with Officer Jonathan Salinas, and you testified that he told you, I came close to pulling the trigger. I'm sorry, I got this, my Salinas is confused. Now, you further testified to a jury that the Code of Criminal Procedure, Chapter 2, compels officers to say that they shall arrest. You recall saying that to this jury?
If they have a warrantless arrest authority, yes, sir.
Yes, ma'am. But in all practicality, while that's the black letter law statute, officers always have discretion in how they go about executing those arrests, don't they?
You mean whether to or
No,
not to
ma'am. My
arrest?
question was how they go about executing the arrest. That discretion always belongs to the officers on the ground, doesn't it?
I I can't say I totally agree with that because I may have a plan of how I want to facilitate an arrest.
Yes, ma'am.
But if my suspect is not cooperating, then my plan's not going to work.
Yes, ma'am. But again, your adaptation to what the suspect does, that's still within officer discretion, isn't it?
Yes, sir.
It has to be that way because the bureaucrats that write the laws aren't out on the ground, are they?
No, they're not.
In fact, it always rests with the officers on the ground, doesn't it?
I can't say I agree with that totally because it...
Well, what situation would you want to have bureaucrats or anyone else that impel an order, but the officers on the ground don't have the final authority? When should they just drive on regardless of what they see in front of them?
That's difficult to answer because
Yes,
there's
ma'am,
so
but
many
you said
variables to it.
You said you
Does she ask
couldn't
an
agree.
open-ended question? Can she think it through and answer, please?
In addition, the question was vague.
It's just open-ended, so let her contemplate and answer, please.
Actually, it wasn't. My question was, you'd agree with me that the officers on the ground have to have the final say in how they execute an arrest. She said she couldn't agree.
That wasn't the question he asked.
Okay, let's get the next question.
You testified that you would not leave an infant alone with Melissa Perez, correct?
Yes, sir.
And I'm thinking counsel asked you that, talking about the older gentleman, Mr. Santos de la Rosa, who was in that first bedroom to the left of this balcony. You recall that?
Yes, sir.
If there was concern about the welfare of Mr. de la Rosa because of Mr. Perez's behavior, which the officers had been observing, with 15 officers on the scene, it would be prudent to probably have somebody keep an eye on him and ensure Ms. Perez is not a threat to him. You'd agree with that, wouldn't you?
Or keep an eye on Miss Perez so they could see that she was not a threat to him.
Okay. And so you're saying that an officer should be designated if she moved into the room, they'd go forward and follow her? Is that the plan?
I don't think there was a plan to do that.
Thank you, ma'am. I agree with you. There was no
Didn't
plan.
let me finish talking, but okay.
I'm sure counsel will allow you to follow up, ma'am. You testified that you should if you had been on the ground in the early morning of 2 a.m., June 23rd, and you were supervising the apprehension for Melissa Perez, what would you have done to arrest her, take her into custody without it resulting in her death?
At what stage are we talking about?
Well, let's talk about this. You saw the opening argument for Mr. Nesbitt and defendant Flores, correct?
Yes, sir.
And he talked about, after that demonstration of how he used the word Melissa Perez compressed the distance between the officers in the patio and her inside the room. You remember that statement?
Yes, sir.
And in your experience, when did you retire, ma'am?
In 2020?
Okay. And so you were always in compliance with TCLO requirements when you were serving, correct?
Oh, yes.
Okay. And You then familiar with the concept of distance plus cover equals time in a tactical scenario, correct?
Yes, sir.
Space between you and I and the time that it takes either one of us to close that distance, that provides extra time to plan, adapt, and react, doesn't it?
That's correct.
And it was, again, stressed that Melissa Perez from inside her home was compressing the time for the plan that Sergeant Flores carried out, correct?
Yes, sir.
But didn't he also close the distance when he sent Villalobos back into that patio? Don't the two work together? He was actually eating into his own decision cycle, wasn't he? It's a yes or no question now.
I don't know how you can make an arrest without making an arrest and closing in on someone, or so I really don't understand the question.
Well, before Sergeant Flores said go, and Officer Villalobos climbed up on the rail, the hammer was down on the couch, wasn't it, ma'am?
Yes, it was.
And so you had time, you had the distance, at least 6 feet from the wall to the railing, and whatever distance she was back into the room, be it the other side of the TV to the center of the hall. That's distance, and you had time, correct?
Yes.
And the only thing that compelled Sergeant Flores to send Officer Villalobos to close the space is he just decided to do it at 2:02 and some seconds. Isn't it, ma'am?
Yes.
Could have happened at 2:10, couldn't it?
Possibly.
Could have happened at 2:30 or 3:30, couldn't it?
Yes.
They could have kept engaging with Melissa Perez, and she might have, since there's evidence about her alcoholism, she might have succumbed, passed out. Again, that was a choice with Sergeant Flores as to when to execute, didn't it?
Yes.
Wasn't it? And from what we've already seen, because until Officer Villalobos jumped that rail, she was content to stay behind that television, wasn't she?
I don't know about that.
Well, let's go back to the beginning of States 10, and you tell me where she is.
If she was content, I can't tell you that she was content.
I'll rephrase.
I'm going to object to this line of questioning because it's not relevant, and the reason it's not relevant under Rule of Evidence 401, 402, and 403 is that counsel is mistakenly believing that tactical choices results in causation. We know that under Section 6.04 of the Texas Penal Code that you have to prove that a cause is sufficient in and of itself is sufficient to cause the result. Nothing that the officers did caused Melissa Perez to charge at them with the hammer of the deadly weapon.
And, Your Honor, the evidence has already been in before the jury. My question is following up this line with the witness, her familiarity with time and space, and what the defense has already brought out about how Melissa Perez compressed the distance. I'm simply pointing out how the defendants also forced the pace and closed the distance.
And, Your Honor, it also ignores the fact that under 38.03B2 of the Texas Penal Code, a person is not allowed to resist arrest. So there's a lack of causation. The police can use any tactics necessary to make an arrest, and that does not mean that they caused the suspect to engage in deadly conduct. This is not logical. It doesn't fit under Rules of Evidence 401, 402, 403. We'd ask you to do the analysis. It causes needless confusion and repetition. It misstates the law. It misstates the law because that's not what 6.04 requires or 38.03 permits. And this is a backdoor way to invade rulings that the court has already made on these issues.
And as counsel is well aware, when it goes into the totality of the circumstances, I am simply pointing out what the jury sees, knows, what this witness has started to testify to.
The totality of the circumstances focuses on...
May I finish my response, please?
Well, I thought you were. Go ahead.
Let's go ahead. Go ahead, Darrell.
In the same spirit of my line of questioning, Judge, I'd like to continue questioning the witness about the answer she gave. She's already started answering about how this compression of time and distance, this is a choice made.
All right, listen, I'll conduct a 403. I'll overrule. You can ask your question.
Thank you. Madam Court Reporter, could you read back where I was my last question?
Question, well, let's go back to the beginning of States 10, and you tell me, answer if she was, question where she is, answer if she was content. I can't tell you that she was content. Question, okay, I'll rephrase. Mr. Cifuentes, I'm going to object.
So, now, you change your verbiage, you can't know another person's mindset. But my question was, we know that at various times, from the officer's statements, and Officer Villalobos in particular, he acknowledged she puts the hammer down various times throughout, correct?
Yes, sir.
And specifically, and I'll move on, we'll move to approximately 157 in States 10. For the record, Your Honor, at 157.02. I want to go to States 3, approximate time off the defendant Villalobos' body on camera.
Miss Flores, you don't want to come on and talk to me?
They kicked the door in, whatever happened, okay? No, but listen. Listen, okay? It doesn't negate the fact. It doesn't negate the fact. Okay. Listen to me what I'm telling you. I heard what you had to say.
Hey, sorry, bring her. So she don't got the hammer on her right now? Yeah, that's right. If I hop over and talk to her and she stays there without me to cut the hammer, the door's unlocked. Yeah, let's just leave. Push her to get her with it. Let's get the door. If that was the case, I could just open the door and grab her. If she doesn't go for the hammer right away, I can just go and grab her. It's on the couch. It's a good little way from her. She won't have enough time to get it if she stays at the door. But whatever. I'm just saying I can get her from opening the door. And we knew that it's just because she. I don't have it. Okay. Yeah.
So that's when you come out and talk.
And so, per my question, there's no one inside the patio, correct?
Yes.
And she's put the hammer down, correct?
Yes.
So that time and distance thing that we talked about, there's time to think, time to react at this point, correct?
Yes.
moving forward in states 3.
We're in the wrong.
Now, for the record, we paused at 2:01:59. Now, at this point, Officer Villalobos is on top of the rail, correct?
Yes, sir.
The distance, time, dynamic we've talked about, it's still pretty much set, isn't it?
Yes.
Okay? At this point in time, and Melissa Perez is pointing directly to Officer Villalobos, correct?
Yes.
At this point, could he have fallen back and disengaged? Yes or no?
Sure.
Okay? Because that would have given more time to decide and react how to proceed, wouldn't it?
If they decided to delay the arrest, yes.
If they decided, so that was a choice to proceed. Is that what you're saying, correct?
Yes.
But at this point in time, this minute right here, this point in time, there's no immediate threat to any of the officers, is it?
No.
Okay. No immediate threat to Santos de la Rosa?
No.
You spent some time in direct exam with Mr. LaHood talking about the justifications and defenses in Chapter 9. You recall that line of questioning?
Yes, sir.
Chapter 9, specifically Section 9.04, you familiar with that section?
9.04. No, sir, I don't
Threats
believe I
is
am.
justifiable force.
Oh, yes.
And what does that section of the code, justifications and defense, what does that provide for?
Judge, can you let her see it? I mean, they don't have it memorized. Can they just have her review it?
She hasn't said she has any difficulty, Your Honor, and now that he's told her to come look at it, I would...
Let's just save some time and have her look at it, Judge.
Your Honor, I'd like to continue my questioning. Okay. So, you're familiar with it?
Vaguely, yes.
Okay. May I approach the witness, Your Honor?
Yes.
And if you can trust me, it's...
Oh, I don't trust you, Mr. Harris.
All of a sudden, I went back to feeling like a baby prosecutor all of a sudden. Okay. Section 9.04.
Threats as justifiable force. Yes, the threat of force is justified when the use of force is justified. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor's purpose is limited to creating an apprehension that he will use deadly force if necessary, that does not constitute the use of deadly force.
Okay. And that's in the same code with the self-defense, same chapter of the penal code with the self-defense justifications, the justifications to use deadly force. They're all contained in the same section, correct?
Yes, sir.
Judge, what is it? I let him finish his question. What's the relevance? You've already ruled on this, with all due respect, ridiculous theory but it appears they're saying that Melissa Perez had the right to use force, deadly force against these officers, which is crazy. If that's where they're going, then we should have a hearing outside the jury's presence. They heard about this before. You made a ruling on that, Judge, that is not an appropriate, it's not even a defense theory to use against these officers, or any officer, by the way, Judge. So what's the relevance of this? You've already made a ruling.
Your Honor, I've asked my question. I'm prepared to continue.
Then a question without a purpose is irrelevant.
Are you going to stay on the same topic?
Your Honor, as the witness said that she was familiar with Chapter 9, the defenses and justifications, and that's all I wanted to do was bring out and tie it together with a prior question I'd asked.
How? Then I'm asking for the relevance.
Okay, let me excuse the jury for a few minutes. We'll let you know when we're ready.
All right, to the jury.
Please be seated.
All right, so that is a violation of the rule, right? To talk about self-defense?
No, Your Honor, if I could.
Please.
Okay. Your Honor, they went into great detail about the officers holding weapons on her at various times, and the silliness of why they're not charged with a crime here. This statute applies equally to them as it does to Ms. Perez about the production of a weapon. The production of a weapon, or otherwise, as long as the actor's purpose is limited to creating an apprehension that he will use deadly force if necessary, does not constitute the use of deadly force. So it helps explain why the officers weren't committing a crime at the time they draw their weapons, and it helps explain why her parading in her apartment holding a hammer is not a use of deadly force, or a threatened use of deadly force, until she uses it in a threatening way that's other than limiting to creating an apprehension that she will use deadly force. It has nothing to do with her throwing the candle. It has nothing to do with having the jury instructed on 941 and 942. It goes into understanding when they keep claiming that she committed 5 aggravated assaults on a public servant, that she didn't, that there is a lawful way of exhibiting force, and there is, even for her in those circumstances.
See, this is exactly what I told you they was going to go into, Judge. And we know under 931, you can't even resist arrest. And this is resisting arrest by force, which is actually a felony, and they're trying to justify that, which is absurd. And that's why we keep using those terminology. So they're doing one of two things. They're trying to equivocate her behavior and her use of force to their use of force, and saying, well, they weren't charged, so she shouldn't have been charged, and she was justified. If they want to stipulate that they had a right to draw their weapons because she was exhibiting deadly force, that's fine. They can stipulate to that. But to try to equivocate their behavior to Melissa Perez's behavior when they know clear and well that the statute does not allow you to resist arrest with any force. We know that, Judge, because you're trying to arrest me. You're going to get arrested either in there or out of here, Thompson is going to testify to, and we saw in there. So they know what they're doing. I don't even know what to say. I'm going to be really careful with my words because I want to be careful, but this is an inappropriate argument that you've ruled on, Judge, and they intentionally continue to violate this court's ruling. So either they don't respect this court or there's ignorance or intentionality. I don't know what it is, Judge, but it's inappropriate.
Your Honor, the first line of 9.04, threats as justifiable force, reads, the threat of force is justified when the use of force is justified by this chapter. 9.31 clearly says you cannot use any force to resist arrest. And the court has ruled on that. And I don't know how many times these gentlemen have to be told, and yet he purposely does this, throws this skunk in the jury box when he knows it's not the law and that you've been instructed on it. This is outrageous. If he's asking her about 9.04, if he would just read the first line, he would know it's not an application of the law in this case. He was like, oh, read all of chapter 9. You've got to read them in conjunction. 9.31 says you can't use force to resist an arrest.
And Your Honor, I think that the egregious, I had objected earlier, and perhaps the court didn't realize why I had objected, but I anticipated that they were going to do exactly this. And they feigned that they weren't going to do that, and feigned that they were just asking questions. Well, this "I'm just asking questions" is Nemo touching the boat when we know this court has said don't touch the boat. It's intentional. And I don't know how many times you keep on making a mistake when it's not a mistake anymore. It's not good faith. It's on purpose. It's willful. And because it's been so willful and blatantly in disregard of the court's ruling, I think this court should grant a mistrial with prejudice.
Okay, well, Judge, and we know the procedure on that. You're very familiar, unfortunately, with this prosecutor and that whole set of circumstances. And we don't want to ask for a mistrial, Judge. We don't want to. But all we can do is interpret this as intentional to try to induce a mistrial. So because we have to, on the record, ask for that, even though we don't want it, but we're asking for a strong rebuke of this behavior and an instruction for this jury not to disregard, but that you made a ruling on this before, and that statute is inapplicable and shouldn't have been asked. Something strong to correct this before this jury, Judge.
And in our motion for directed verdict, I pointed out that because the court has taken away all of their so-called theories, they don't have a vehicle now to get to this jury on meeting the use of deadly force at all. So now they fall back on this, which is a misapplication of the law, intentional. So I would ask the court, I would renew our request for the court to direct a verdict. They don't have any means of getting their theory, their cockamamie theory, to this jury anymore, so they throw another skunk in the jury box. I don't know how many times the court has to instruct these two, and yet it continually happens.
And Judge, we keep saying this, and it's very simple. Chapter 9 is a defense to prosecution. It's none of these other things that the state is saying. It is a defense to prosecution. All the other arguments I agree with, but they don't apply because it's a defense to prosecution. Melissa Perez's actions are not being prosecuted. She's not on trial. These gentlemen are. None of this applies.
All right, so I will sustain the defense objection. I will deny the motion for mistrial. I will instruct the jury to disregard the last question, and I will instruct the state to follow the law.
And Your Honor, I realize that...
And this is a very clear legal issue.
Yes, Judge.
This is not a confusing, complicating issue. It's very clear, and the way Mr. Norton described it, he described it best. I mean, this is not, Chapter 9 does not apply. We know that, right? In the manner that you're using it. So let's not do that anymore.
And Your Honor, I realize you said you're going to instruct the jury to disregard the last question, but I believe that my previous objection that was overruled, they should be instructed to disregard the response to that question as well.
They're not.
What was that response?
It was a question that was asked about 9.04. So I would ask that the jury be instructed that the state's questions about 9.04 that have been asked in the last 20 minutes be disregarded.
And Judge, can we humbly suggest that the court instruct the jury that all of Chapter 9, as Mr. Norton pointed out, applies to people accused of allegations. I'm not going to say improperly used, but doesn't apply to the state's questioning or to their theory at all. I mean, that's something strong like that to correct, because this continues to happen, Judge, and I don't know what else to ask and suggest.
I would even ask the court to consider a stronger instruction to the jury. This has happened so many times, and we're forced to object, and the jury is thinking, oh, the defense is hiding something, and because they continually do it, it looks like we're hiding something when they continually violate this. I'm asking the court to, if the court's not going to direct a verdict, if the court's not going to grant a mistrial, I respectfully ask the court to consider an instruction which has been done before in prior cases about the misconduct of the state, and going on the record and saying that they've been warned not to go into this anymore. I don't know how many times they visit this well intentionally and they get spanked, and yet they go back and do it again.
And I would ask that regarding 9.04, that the court instruct the jury, as Mr. Norton has said, is that Chapter 9 justification only applies to the people on trial, not to the complainant named in the indictment.
Okay, all right, let's take a short break, very short, and then we'll come back. right, welcome back, members of the jury. I told you after I swore you in that I'll give you instructions throughout the course of the trial. I'm going to give one to you now. The court sustains the defense objection to the last line of questioning. The jury is instructed to disregard all questions asked by the state and any testimony elicited in response related to the suggestion that the complainant, Melissa Perez, had a justification for her conduct under Chapter 9 of the Texas Penal Code. You are instructed that she did not. At the conclusion of this case, you will be instructed on the law that is applicable to this case. There will be no instructions related to whether Melissa Perez had the legal right to resist the defendant's attempts to arrest her. That is not an issue in this case, and you are to disregard all testimony related to that issue. All right, State, you may continue.
Before the break, we were looking at Officer Villalobos' body cam as he started the execution of the plan. We are on his video states Exhibit 3 at approximately 02:01, 59 hours. Do you agree?
Yes, sir.
Okay. And does the facts at this point in time allow for him to fall back? If Sergeant Flores had directed, could he have fallen back? Moment, Your Honor.
Yes.
All right. From this point, she's clearly aware that they're coming over the patio, correct?
Yes, sir.
Did they still have the authority to disengage, fall back, and re-engage?
Objection asked and answered and irrelevant. And it's irrelevant under 401, 402, 403. And it's also an attempt to mislead the jury under causation under 6.04.
I'm simply asking about the choices made and if they had the ability and authority to fall back.
I'll let you rephrase it.
Could the officers have fallen back, disengaged at this point?
If they wanted to, yes.
Okay. You answered if they had wanted to. Is it the only issue what they wanted, or should they be taking in all the information and all the stimulus and reacting to facts as they are?
Objection, it's irrelevant, it's misleading. We object under 401, 402, 403. It misstates the issue of justification. The question does not, as phrased, does not address the crux of justification under 9.31, 9.32, 9.33, or 9.51, and it additionally is a backdoor way to suggest that officer-created peril is a justification for someone to illegally resist arrest.
I'll sustain.
You'd agree with me that tactical decisions in the field should be based on what you can observe and the information you get from your subordinates. You'd agree with me on that, correct?
Objection, Your Honor. Tactics has nothing to do with the issue of justification. This is improper under Barnes v. Felix, which is a United States Supreme Court decision. It's improper under Graham v. Connor. It's irrelevant under 401, 402, and 403, and tactics does not create the causation or the nexus in this case under 6.04, and this is a backdoor way of violating the court's prior ruling.
Your Honor, again, the witness answered the question based on, quote, had they wanted to. I'm simply exploring that with what the plan they're trying to execute.
All right, so it's not conductor 403. I'll sustain the objection and say, ask them that in the manner that you're talking about, rather than getting into the 403 issue.
Understand, Your Honor, but that was, all of that injection was counsel's objection. So that's not what I asked. Okay. Sergeant Miller, and again, your answer to my last question was if they wanted to, correct?
Yes.
Okay. All information points are important in acting safely out in the field, aren't they? All information points.
Yes.
And you'd agree with me that as we are paused on Officer Villalobos' body cam at 2:02:01:59, that is an information and data point, isn't it?
No, I would disagree with you.
And how is it that this point in time on the body cam, why is that not a data point for the man in charge to consider? Why is it not?
Because once you gather all your data points that you're talking about and you come up with a plan to execute and you begin executing that plan, then you execute the plan. That's just the way it works. So if one member decides, oh no, maybe we shouldn't do this, some other guy says, oh, I've changed my mind, I don't think this is a good idea, you're just creating chaos. So that the plan was made, everyone agreed to it, and they began the execution of the plan. That's it.
Okay. Maybe a background I share with maybe some of the defendants, their prior service. You ever heard the phrase in battle, the enemy gets a vote? You ever heard that phrase?
No, sir, I was in the Air Force.
For the record, I'm glad you said that, and I won't be accused. An Army beat you all this past weekend. But from your time in the street as a patrol officer, you'd agree the people you're trying to arrest, they can make it, as Sergeant Thompson says, one way or another, they're going to arrest you. Go easy and go hard, correct?
Yes, sir.
Okay. And so I understand your testimony, though, is once you have a plan, it's going forward regardless of any new information or changes. That's your perspective, isn't it? It's a yes or no question, ma'am.
That the plan is going forward, what, again?
It's being executed. This is what I understood you to say.
Yes.
The plan is the plan. We've all agreed to it, and we're driving on. We're going forward.
Yes.
And it follows then that no additional information would change it once you decided to engage, correct?
I never said that, no, sir.
I apologize. But the plan is the plan. That's your position.
There's a fluidity to any plan.
Okay.
Suppose they were going to go into the house and all of a sudden her 4 grown sons came out of the back bedroom. Well, that would change the plan a little bit. So there's fluidity to plans, but they're not required to change anything about the plan.
No, ma'am, I'm not saying required, it's an information point. We can agree to disagree. Just one moment, Your Honor. Your Honor, I'll pass the witness.
All right. Sergeant Miller, I believe questions were asked of you about the warrant.
Okay, I'm sorry. I directed, so yes, then you have to talk.
All right. So, I believe questions were asked of you about the warrant. Do you recall that?
The arrest warrant?
Yes. That's what they obtained.
I don't remember what the questions were, but okay.
Okay. All right. So you're familiar with the concept of a material omission in an affidavit for arrest, correct?
Oh, yes.
Explain that to the jurors.
So when you're getting your affidavit for your arrest warrant, you don't have to spell out the entirety of your case to the judge, but you have to give them enough information that they can make a decision whether or not they agree that you have probable cause or you do not. But you have a responsibility to the judge to be truthful and tell enough of the story that he gets the realistic picture of what you're asking of him, what the situation was. If there's something that's material or like extremely important in your case, the judge or the magistrate needs to be aware of that. And if you purposefully or even subconsciously leave out critical information like that, you're doing a very grave disservice to the magistrate or the judge, because they are now signing a warrant that they believe is true in its totality. It's like, is not telling the truth the same thing as telling a lie?
All right. And in this case, you heard Detective Soto admit that he left out the 2 hammer strikes that Melissa Perez made against Jonathan Salinas at approximately 1:40, 50 or so, somewhere in that time frame, when Melissa Perez swung the hammer when she was charging at Jonathan Salinas after he hopped over, stuck his head in, and Officer Rojas yelled, "Watch out, watch out, watch out, watch out." Hey, do you remember that?
I do.
Would that be a material omission in your opinion?
Yes, and he not just left it out of the arrest warrant affidavit, he left it out of the offense report too.
All right. And you also understand that in his arrest warrant, he said that no reasonable officer could have concluded that Melissa Perez was threatening imminent deadly force. Do you recall that?
I do.
And was that a truthful statement?
I don't believe it was, because...
And based upon your interviews with Maria Salinas and Vince Gomez and Travis Thompson, and I believe you also spoke with Andrew Lamb, did you not?
I did.
And based upon your interviews with them, did anyone ask them specifically whether they believed that Melissa Perez was threatening deadly force, serious bodily injury, or death.
Objection, Your Honor, invades province of the jury, along with hearsay, but again, asking these witnesses.
Shouldn't rely on hearsay, Judge, she's an expert.
Again,
And this goes to whether there was material omission in the affidavit.
she can, Your Honor, she can form the opinion, but as the question was posed, it's irrelevant to this jury.
All right, you can rephrase your question.
All right. You read all of the written statements that the homicide officer-involved shooting team took on June 23rd, 2023, correct?
Yes.
And in fact, you've reviewed all of the body-worn cameras of the 15 officers that were on scene, correct?
Yes.
You reviewed them from beginning to end, correct?
Several times, yes.
All right, and on top of reviewing them from beginning to end several times, you've read transcripts of those body-worn cameras, correct?
Yes.
And those transcripts are complete and were accurate, correct?
Objection is the bolstering, Judge.
I'll sustain.
All right. And did you find any deviations between the transcript and what you viewed on the cameras?
Nothing significant, no.
All right. And did you review the grand jury testimony of certain witnesses?
I reviewed the grand jury testimony of probably 2 or 3 witnesses.
All right. And also you spoke to Andrew Lamb, right?
Yes.
And you recorded your interview with him, right?
I did, yes.
And you had it transcribed?
You had it transcribed.
Okay. And you've read the transcript?
I believe I did.
All right. And would you agree that no one in the officer-involved shooting team, and neither Detective Soto or anyone else, asked whether the witnesses you talked to, Andrew Lamb, Vince Gomez, Maria Salinas, Travis Thompson, no one asked them, was it reasonable for these defendants to use force? No one asked them that.
No, and I would say overall, all the statements that were taken in homicide that night were poorly done.
And why were they poorly done?
They didn't ask the pertinent questions of the officers to get to the justifications in Chapter 9. It's like they didn't even try to apply Chapter 9 to this situation.
All right, and you heard Detective Soto explain that it was a team effort and they collaborated with each other. Did you see any effort, any evidence of collaboration in any of the supplemental reports that the detectives wrote?
No, and I saw just the opposite from Detective Platt, saying if it's somebody else's case, I just let them tell their story, but if it's my case, I go into more detail with my witnesses. I'm like, what are you guys doing over there?
All right, is that, the testimony of Detective Platt, is that antithetical to teamwork and cooperation?
Yes, absolutely.
All right. And also, if an affidavit for an arrest is untruthful, does that destroy the credibility of the affiant?
I would imagine that's for maybe a judge or somebody to decide. If you're asking my personal opinion,
Yes.
Yeah, that's horrible.
All right. Now, you heard the custodian of records in this trial say that if you fail to document it, it means it didn't happen. Do you agree with that, or do you disagree with that?
I kind of disagree with it, just because I know how crazy homicide investigations can be. I may not make a physical note of something, but I do remember it in my head. So to say I didn't document it, that it didn't happen, I guess the question is, can I prove it happened without documentation? I guess that depends on how persuasive you are as a speaker, maybe.
All right, and you saw that Detective Soto reviewed 4 body-worn cameras in detail in his prosecution guide, correct?
Yes, he made inaccurate details of the body-worn cameras that he has in his prosecution
He
guide.
attempted to make a detail.
Yes,
But they weren't accurate, is what you're saying?
correct.
All right, and did you see the remaining 11 videos detailed summarizing what happened?
No.
And based upon the failure to write notes or detail what happened in the other 11 videos, do you have an opinion as to whether the lack of documentation means that he didn't review them?
I don't believe he viewed them. I mean, I know for certain that Travis Thompson's specifically was not viewed until November of that year, when the incident occurred in June. I mean, for me, that's inexcusable. Travis Thompson has some very important information in the investigation, and Soto didn't even know it till November.
And did you notice that in Detective Soto's prosecution guide that he incorrectly stated twice that Eleazar Alejandro could not see when he fired the first volley and the second volley?
Yeah, that was an interesting notation, and I don't even know why it was included in there, because it's not factually true.
All right. And are you familiar with command influence, given that you have experience in the military?
Well, I don't need my military experience to prove that to me. Yes, I'm aware of, and I was the recipient of making the mistake of standing up to our administrators at one point. I know it's hard to believe because I'm so easygoing, but I did. And yes, I got sent to timeout for a few months for standing up to the administration.
All right, and in this case, can you tell the jury whether there's evidence of command influence based upon your review of Captain Van Geffen's memorandum?
I believe there was probably some pressure from the administration for Detective Soto to take the action that he did.
All right, and you heard testimony from the CSIs about Chief McManus being in the inside the crime scene for a significant period of time and on scene for over an hour. Based upon your experience as an investigator, should he have signed into a crime scene log indicating that his presence inside the crime scene?
Yeah, I think that was something else that they failed to do in this investigation, was to even keep a crime scene log. So nobody signed in on the crime scene log because they didn't do one at all.
And was that required by standard investigative procedures of the San Antonio Police Department?
It is.
All right. And in the questioning of witnesses and grand jury, and have you also read prosecution notes of disclosures of statements that witnesses have made to the DA?
I've looked at, yes, several of those, yes.
And have you heard testimony that's unveiled in the course of this trial and see that there's a variance between the disclosure and the statements and the witness testimony that we hear from the witness stand?
Yes.
And what does that indicate to you?
That the questions were being directed to support the conclusion that was made instead of really wanting to know the truth of what had happened. Just little things like nobody asking, you were an officer, you were there, do you believe your fellow officers were justified in using force? That question was never asked of any of the officers that were there at the scene.
Objection, Your Honor. We'll just strike this again. Counsel's debating province of the jury. The ultimate decision is theirs. Any other officer's opinion given to this not even given to this investigator is not relevant.
Every response can't be invading the province of the jury, Judge. We have a legal objection. I know it hurts them what she said, but that's not our proper
Relevant,
objection.
Your Honor.
Okay, well, it is relevant. Any tendency to prove or disprove a material fact in the case under 401 is the definition of relevance. Under 402, then it's relevant, Judge.
And it was based off interviews and documents passed. It does not tend to help prove a material fact.
The objection was untimely as well.
Overruled.
So, based upon your testimony, would that be akin to having forced blinders on to avoid looking at favorable evidence?
That's the way I saw it.
And are you familiar with a message that Chief McManus distributed to all roll calls in March of 2016?
That was after an officer-involved shooting, or?
Yes.
Yes.
All right. And that message that Chief McManus gave to all officers, did he ever say that he expects officers to retreat?
The expectation was that you would not retreat.
Ask the witness.
I have no questions, Judge. Thank you.
There was some other people you spoke to as well. Did you speak to Sergeant Rivera and Sergeant Robertson also?
I did.
Will you please, I guess we'll go Rivera or Robertson. We'll start with Sergeant Rivera. Can you share your conversation that you had with Sergeant Rivera, please?
Objection, hearsay, Your Honor.
Judge, we've already been through this already, this exercise before. She's an expert. She can rely on hearsay. She's testified to hearsay before and they haven't objected. And so this is the same line of questioning with a different witness.
Your Honor, hearsay only comes in with an expert if it's something that helps form the conclusion. They can form a conclusion through hearsay. They can't testify to what people told. It's hearsay.
All right, so the question was, can you recall your conversation that you had with Sergeant?
Yeah, I'll ask about that, but they questioned her opinion, Judge, so we have a chance to
Yeah.
they put it into question themselves.
Well, the question is just a yes or no answer, so if you can answer that.
Did you recall your conversation with Sergeant Rivera?
Portions of it, yes.
Did your conversation with Sergeant Rivera help form your opinion that you have about this investigation and this prosecution?
Yes.
Can you please share your conversation with Sergeant Rivera, why that supports that conclusion?
Your Honor, again, the question calls for hearsay. What's relevant is her opinion based off that conversation.
We made this, just talk about that conversation, unless they're just going to take her word for it, which I'm happy, stipulate that what she says is truthful, and we don't have to talk about the conversation.
Okay, you can rephrase your question.
I know the rules before you follow them. And so let's talk about this conversation with you and Sergeant Rivera, okay? Did your conversation with Sergeant Rivera help you form your opinion not only on this investigation, but the prosecution as well?
Yes.
What about that conversation helped you form your opinion?
How can I say this without saying what he told me?
You can say what he told you if it helped you form your opinion.
She can just say what her opinion is, Judge.
No, they're not going to question that?
Well, the conversation would come in if it is the basis of her opinion.
Exactly, Judge.
I'll let her answer that.
So given the political atmosphere after the George Floyd situation and riots, several of us, we reached the conclusion that there was some political pressure from the chief's office to arrest these officers.
Now, did you recall your conversation with Sergeant Robertson?
Yes.
Did your conversation with Sergeant Robertson help you form your opinion on the investigation and the prosecution?
It fortified the conclusion that I was kind of suspicious about, yes.
And your conversation with Sergeant Robertson, did it coincide, or was it consistent with your conversation with Sergeant Rivera?
Yes.
Is it a similar conclusion?
Yes.
Did Sergeant Rivera have an opinion on whether it was a legal shooting?
Yes.
And what was that opinion?
He felt that the shooting was justified.
And did they talk to the district attorney's office?
I can't recall what he told me about that. It was too long ago.
Okay. Do you believe that the DA's office in prosecuting this case should have talked to someone like Sergeant Rivera from the scene?
Oh, yeah, I don't know how you couldn't talk to Sergeant Rivera.
Do you know who Officer Pedraza is?
Yes, I do.
Who is this gentleman?
He was the sergeant in charge of tactics and shooting at the police academy at the time that the shooting occurred.
Did you have an opportunity to talk to Sergeant Pedraza?
I did.
Did your conversation with Sergeant Pedraza help you form your opinions of not only Detective Soto's investigation, but also this prosecution?
It reinforced the conclusion that I had already reached, yes. Disturbingly so, yes.
What was disturbing about your conversation with Sergeant Pedraza?
That he was called to a meeting at the chief's office between 8:30 and 9 the morning of the 23rd, and that the administration had already made the decision to arrest the officers. That was like 2 hours after they finished getting statements from the officers. The decision had already been made to arrest them.
Did they give him any instructions or any perceived threats to Sergeant Pedraza?
Yes, he disagreed with that decision, and he was told to keep his mouth shut if he wanted to keep his position at the academy.
Do you know if Sergeant Pedraza was spoken to by the DA's office?
I don't know that.
Should they have spoken to him, in your opinion?
Either him or Juan Manejando, either one of the two.
Who is Juan Manejando?
He's in charge of the tactics training at the academy.
Your conversation with Sergeant Pedraza, is that consistent with what you learned about Captain McGaffin's meeting with Van Geffen's meeting with the DA's office, and then his ultimate decision to charge?
Actually, talking to Sergeant Pedraza kind of solidified what I was suspicious of, that there was bias in this investigation, and that was the only explanation I could find for all of the errors and omissions and mischaracterizations in the prosecution guide. Like I couldn't figure out why I was seeing what I was seeing until I talked to Sergeant Pedraza, and then I said, oh, okay, so they made the decision first thing in the morning. The entire prosecution guide, the entire investigation subsequent to that became tailored to supporting that decision to arrest the officers.
Your conversations with Sergeant Pedraza, your review of Captain Van Geffen's reports, and your conversations with Sergeant Vetta and Sergeant Robertson, were those conversations, the information you learned from that, consistent with how Detective Soto testified from that stand?
No.
Do you recall Detective Soto saying that he made the decision to make the arrest?
Yes.
Judge, at this time, I'm going to be asking the sergeant about a reasonable officer standard, because they asked her, if you were the sergeant at the scene, what would you have done? Now that takes it out of her opinion of whether she would have shot, but now she's a supervisor at the scene, which is an overlooker of officers, and so I think they've opened the door to me asking about a reasonable officer standard. May I proceed, Judge? Yeah. I want to give them opportunity to object.
Go right ahead. Proceed, Judge.
Okay. Just want to be fair. So, based off a reasonable officer standard, you believe it was reasonable for Sergeant Flores, under the circumstances he saw and was facing, Officer Alejandro, under the circumstances and what he was facing, and Officer Villalobos, under the circumstances what he was facing and the threats, for them to have shot?
Oh, absolutely.
When the government asked you questions about closing the distance, who made the decision to close the distance and attack?
Well, Ms. Perez did, in response to their attempt to arrest her.
And arresting, as the judge instructed, was a lawful thing they were trying to do?
Yes.
Now, they ask questions about the hammer being down. When you're engaging in a plan, they've heard some questions on this, so I'm not going to belabor it. Is it better to engage a suspect with a weapon or without a weapon?
Well, without one.
So, what would be a safer plan? To engage or to have a plan or to move in to arrest when there is less of a threat or more of a threat?
Less of a threat.
What assurances did you observe from looking at all the evidence and all the body cam that Melissa Perez would not attack Mr. De Los Santos if the officers would have left?
There are no assurances of that.
Was there any question whether Melissa Perez was dealing with uniformed officers?
No, none whatsoever.
In your opinion, from what you observed, did you believe that she knew she was dealing with uniformed officers?
Yes.
They asked you questions about engagement. Could Melissa Perez have decided not to attack the officers with that hammer?
Yes, and she had been arrested and emergency detention several times without attacking the officers in the past.
But this time was different?
This time was different, yes.
When you watch all of the body-worn cameras, do you see a violent person committing multiple felonies to resist arrest?
I do.
Pass the witness, Judge.
So Miller, you'd agree with me that Chapter 15 of the Code of Criminal Procedure governs the requirements for a warrant?
Judge, you already talked about this. Once again, they're violating your rules. There's no requirement for a warrant. It's irrelevant. You've instructed them numerous times.
Yeah.
I don't know how else to deal with this.
Judge, questions have been made about the sufficiency of the arrest warrant that Officer Soto asked. I am simply going over the requirements in the code for sufficiency requisites of a warrant.
About walking a warrant or for the officers to have a warrant?
My question dealt with the requirements of a warrant, the requisites of a warrant, section 1502.
All right, I'm looking at the question. I'll overrule.
Are you familiar with section 1502 of the Code of Criminal Procedure, requisites of a warrant?
Some of them, I haven't read that statute in years. That it run in the name of the state. I don't remember.
Now approach, Your Honor.
Yes.
I don't remember all the things that are on it.
Again, same code book?
Yep. Issues in the name of the state of Texas. Specify the name of the person whose arrest is ordered. State the person is accused of some offense. Must be signed by the magistrate.
Okay. And you would agree that is the section deals with the requirements of a warrant, correct?
Yes.
Now, obviously, there has to be more meat on these bones than just its bare, but to be legally sufficient, that's what it requires. State of Texas, specify the name of the person to be arrested, if known. That the person is accused of an offense, and then signed by a magistrate. Those are the requirements, correct?
For the warrant, yes.
Yes, ma'am. And you yourself, you've probably obtained hundreds of warrants in your career, correct?
Probably. A lot, yes.
And the magistrates, they ask you questions. If it's insufficient, you go back and get more, correct?
They're not allowed to ask questions. They can only evaluate whether they'll sign it or not based on what is called the four corners of the warrant.
And if they don't feel it's sufficient, they don't sign it, correct?
Correct.
counsel asked if the opinion you formed based on your conversations with Sergeants Rivera and Robertson from the night of the shooting. That's what you told the jury, correct?
I'm sorry, what? My
Said that you spoke with
conversations?
both Sergeants Rivera and Sergeant Robertson about their opinions on the shooting. You remember telling them that,
Oh,
correct?
yes.
And had you previously read their statements they gave the day of the shooting?
Yes.
Did they, is it your testimony they told you more than they wrote down in their statements the day of?
Yes.
That's what you're saying. So they intentionally gave incomplete statements. That's what you're telling this jury, correct?
Oh, no. No, not at all.
And what was the variances between the statements they gave the day of and what they told you months, years afterwards?
Because I asked the right questions.
So they had information that they withheld from the statements knowing about the day of. That's what your testimony is, correct?
No, sir.
You've investigated officer-involved shootings in the past?
Yes.
And if you took statements from officers, you'd expect them to tell you what they'd observed, correct?
No.
You would not.
No.
You would not expect officers to tell you if you were investigating. You would not expect them to tell you everything they'd seen.
No.
That's your testimony.
I would expect that I would ask the right questions to elicit the information that we need to continue the investigation.
If you had been supervising Melissa Perez's arrest, could you have done anything that could have resulted in her arrest without it resulting in her death?
Are you asking if there were other options besides arresting her or
No, ma'am.
the manner of the arrest?
You were trying to execute her arrest. You could have done things that would have resulted in her being taken, arrested, without being dead, couldn't
Judge,
you?
I'm going to object to this on relevance ground 401, 402, 403. And this is a backdoor way of trying to accuse the officers of officer-created danger, which is not a legal theory that the courts have recognized for officer liability, either criminal or civil. And even if there's an alternate means to arrest Melissa Perez, the officer's choice and method did not cause her to illegally resist arrest as prohibited by 38.03B2, and which is prohibited under Chapter 9 of the Texas Penal Code. So it's not relevant to any issue in this case, and it's contrary to the instruction that this court read to the jury probably 20, 30 minutes ago.
Witnesses testified on direct about the reasonableness. I will rephrase it, Judge.
Okay.
Your opinion, what would have been a safer plan to effect the arrest of Melissa Perez?
Objection. It's the same way of attempting to, through the back door, accuse these officers improperly of officer-created danger, which does not go to any issue in justification in Chapter 9. And so it's irrelevant under 401, 402, and 403. and flies in the face of causation under 6.04 of the Texas Penal Code and contrary to the Supreme Court decisions in Graham v. Connor and Barnes v. Felix.
Judge, number one, variation of the same question this council asked on cross-examination. Two, correction, Mr. LaHood asked, and two, she's already, based on his claiming that the state opened it, is ask her about her conclusions to the ultimate issue. I've just asked an alternative. What would have been a safer plan?
All right, so I'll sustain a relevance objection, and you could ask that in a very different way.
I'll go back to, remember the line of questions we had earlier in the immediate cross, and I asked you about your familiarity with time and distance, posing at distance, correct?
Yes.
Officers had the option to disengage, didn't they?
Objection asked and answered, and we would object on relevance.
It has not been answered,
It has
Judge.
been asked numerous times.
It's not been answered, Judge.
Overruled.
And I'm not saying leave. They could have left observation. They could have gave it another 10 minutes from 2:02, couldn't they, ma'am?
Sure.
They could have called night CID that night, couldn't they, ma'am?
What would they call night CID for?
They could have attempted to call up higher, yes or no, couldn't they?
Night CID, I don't understand. The role of night CID, or they just investigate crimes after they occur. So I don't know what you would call night CID for.
They could have actually called SWAT, couldn't they, ma'am?
SWAT
It's a
is...
yes or no question, ma'am.
No, it's not.
Your Honor, this is an attempt to get into tactics which the court has already ruled upon.
Again, it's a yes or no question, Your Honor.
No, actually, it's not.
Ma'am, I understand that you want to work a particular answer. My question is, and Your Honor, I don't mean to disregard the court. Can I proceed?
Yes.
They could have chosen to call special weapons and tactics, couldn't they, ma'am?
I'm going to object. I'd like to approach outside the presence of the jury.
All right, so members of the jury, I'm going to give you a break. It's almost 4 o'clock. We'll let you know where you're at.
All right, Richard.
Prosecution. And the grand jury testimony, which Sergeant Miller, I think, has reviewed, is it Captain Moulter or Lieutenant Moulter? Testified under oath, being directed by Mr. Harris, that SWAT would not have gone out there that morning. That they would not have gone out there that morning. He said that under questioning from Mr. Harris, under oath to the grand jury. So now for Mr. Harris to be asking this question in front of this jury, I don't know how much more a question could be asked in bad faith. And Mr. Cifuentes is finding the transcript.
Mark Moulter testified before the grand jury on December 13th, 2023. And in response to a question, he said, and I say that because we aren't going to typically respond to property crimes. And he goes on to explain why SWAT would not have responded to this call at length. So, there's basically asking a question about a what if when the state knows that SWAT would not have responded, and we've already had the court rule that police tactics on making an arrest is not relevant to the issue of whether or not there was justification under 9.31, 9.32, 9.33, 9.51. And so to suggest bad tactics, we filed a motion in limine on tactics, and 2 weeks ago, I believe this court already ruled the state should not be allowed to ask any questions about tactics or put on any witnesses to talk about tactics. So since we filed a formal objection to tactics, and the court sustained it, this is a means through the back door to get around the court's prior rulings. And this is just highly improper. It's willful, it's intentional.
Your Honor, if I may, as counsel read the transcript, the question asked, SWAT does not respond to property crimes. There has been testimony that this was assault of public servant, aggravated assault, attempted capital murder, and my only question was, did they attempt to call SWAT? They defined it as not beyond what was asked at grand jury. That's what this jury's heard.
Judge, if they want to predicate the question with there was all these multiple aggravated assaults and all the things that they just said to differentiate it from a property crime, then okay, maybe let them ask that question. But just to say you could have called SWAT gives a false impression. If they want to add in ag assaults on police officers and all those kinds of information for the jury, then I think it's an appropriate question.
Your Honor, I want to point out, Mr. LaHood asked the same question. He asked her, and we can find it in the record. What would be a safer plan? He asked. What would be a safer plan? And then he paused and said, then waiting for her to put down the hammer to go in. That question, what would be a safer plan, was asked by them, Your Honor, and we should be able to ask our own question about what would be a safer plan and provide alternatives. I don't see the difference.
But that was only in response to their questioning, Judge. Because and everybody's asked questions. Is it safer to go in and try to apprehend someone, which they had a legal right to do, armed or unarmed? That's all that was. I didn't go out any bounds. I didn't violate any rulings. I didn't break your motions in limine. I didn't violate any order from this court. So I was only responding to their line of questioning after it had been relevant, because that is an issue. Is it wiser? Is it smarter to go in and effectuate an arrest on an armed suspect or just an unarmed suspect? That was it. I didn't talk about any further than that, Judge.
And
it's not tactics, thank you.
And then to suggest that we've added new elements, it's laughable that on page 29 of the grand jury testimony, Mr. Harris changes things up by adding a permutation about assaulting the officers, throwing the candle, hitting them in the forearm, and still Moulter sticks to the story SWAT would not have responded. So even with the permutation of committing an assault, aggravated assault against a peace officer, Moulter goes on in page 30 and 31 saying that basically they would have walked away and they should have gotten a warrant, and that SWAT would not have responded. So, this this gets into whether the state, these prosecutors are intentionally violating the rules of professional conduct by misleading this tribunal about what happened in this case. This goes beyond the pale of ethics, of honesty and candor to the court. They're being dishonest, untruthful in what happened in grand jury, and now are trying to suggest to this court an alternate reality. And that cannot be tolerated by this court.
All right, I'll sustain the objection. Anything else?
And we would ask that the jury be instructed, once again, that these misstatements of fact and law be disregarded by the jury.
All right, let's take a short break.
May be seated.
All right, welcome back, members of the jury. I'm going to instruct you to disregard the last question asked by the state, and I'm also going to remind you of the paragraph that I read to you after that last break. State.
Sergeant Miller, you also testified on video. You said there were material omissions in the warrant.
Yes.
Approach witness, Judge.
Yes.
Showing you what has been marked in State's Exhibit number 197 for identification. What is 197 for identification?
The affidavit for the arrest warrant.
Okay. And if you would just, on page 1, the paragraph that begins, officers continue to speak. Just read that paragraph to yourself.
Okay.
Does the affidavit tell the magistrate about the assault on Officer Salinas?
About the assault bodily injury, yes. The assault with the hammer, no.
Okay.
And again, the requirements of 15.3, is it required that every act be represented in the affidavit?
Ethically, you need to include the material information in your affidavit.
Looking at page 2.
Yes.
The sentence, the approach witness again, Your Honor?
Yes.
Third one down, beginning with Y. You just read the balance of that paragraph.
Okay.
All right. And does the affidavit reflect Melissa Perez obtaining a hammer, rushing at the door where Officers Villalobos and Flores stood in the patio?
Yes.
And does not say that Detective Soto viewed all the digital evidence, all the physical evidence, does it?
Well, we skipped over a whole bunch here. Was that intentional? Oh, I'm sorry.
No, ma'am.
I'm used to running the investigations. You gotta forgive me.
I understand, ma'am. But again, we went over those requirements for the affidavit to be legally sufficient, correct?
Yes.
So, when you say that there were untruthful or misleading statements, you mean he didn't include everything from your perspective that's working for the defendants. That's what you mean when you say untruthful statements, correct?
No, sir.
Really?
You want me to explain?
No, ma'am. The affidavit lists where it occurred, and it lists the assault on Officer Salinas, doesn't it?
The assault on Salinas with the candle, yes.
Yes, ma'am. And the jury's seen the evidence of the hammer blow that knocks the screen out. It looks to me that the screen's falling out once Salinas tears it and it's coming out, but it falls down to the floor as Salinas is backing up. I understand you want to call that an assault. The affidavit does include the officers reaching the patio and approaching the door, doesn't it?
Yes.
It does include that Melissa Perez picked up a hammer. And approached the patio door while Officer Villalobos was on the other side, doesn't it?
Approached the patio door, yes.
Okay. It does address statements from Officer Alejandro, Officer Villalobos, Officer Flores, from their statements as to their mindset, doesn't it?
No.
May I approach the witness, Your Honor?
Yes.
Right here. Believing.
But see, that's why I believe that's inadequate. And that's only one of the officers' mental states, not all three of theirs. And Detective Soto actually disregarded that officer's statement later in the affidavit.
Okay, and I'm gonna go back. My question. Officer Alejandro's statement is already in evidence.
Yes.
He put in a statement that he believed Ms. Perez could throw the hammer at Officer Flores.
Yes.
Is the context of that statement in the affidavit? It is there, isn't it?
Yes,
Thank you,
and
ma'am.
then disregarded
Thank you, ma'am.
later in the affidavit. That's the problem. That's the deception that I'm talking about, or the mischaracterization, Mr. Harris. He says in one part, Officer Alejandro was afraid that she was going to throw the hammer. That, sir, is fear, right? But down in the next paragraph, he says, the officers weren't in any danger. That's the deception that I'm talking about. That's the mischaracterization that I'm talking about.
And that was written under the affiance portion of the statement, is that correct?
Yes, sir.
And the affiant here was Detective Soto, correct?
Yes.
And so it's not, it is what he's already testified to as his belief, isn't it?
Judge, I'm going to object to how he's phrasing these questions, because what he's testified to is The affidavit was written before 6 o'clock on June 23rd, 2023, and the testimony is 2 years and 2 months later, and the testimony 2 years and 2 months later is irrelevant to the affidavit 2.5 years ago. So it's misstating what is required in an affidavit. There's no way that someone can have prognostication of what someone's going to testify 2 years later.
Your Honor, if I may, the witness testified that there are misstatements in the affidavit. I am simply asking her from what the Sotos testified to, what the misstatements are.
Well, the misstatements relate to what was written on June 23rd, 2023, not what someone's testifying to 2
And
years
if
later.
counsel could not suggest how he wants his witness to answer,
All right, I'll let you inquire.
You want me to list the things that I'm talking about?
no ma'am.
Okay.
I want you to answer my questions.
Okay.
Is the affidavit does the affidavit state that Melissa Perez charged at the officers a second time?
I don't believe he used the word charged. No, in fact, he says, let's see.
Begins with that word after.
The victim stepped backward toward the hallway, but then rushed toward the defendants. But there's no mention of her swinging the hammer at them. As she moved toward the back door.
Just a moment, you omitted a statement.
Judge, I've asked that she be allowed to answer this question and explain her answers.
You can ask.
And so if you would just read that sentence beginning with the word after, defendant 2.
After defendant 2 fired his duty weapon, the victim stepped backward toward the hallway, but then rushed toward defendant 1 and defendant 3 a second time, who stood outside the closed patio door.
Okay, and so your testimony
Pursuant to
is...
the rule of optional completeness, can she please read the next statement, the next sentence, please?
All right, you can ask your next question.
Can I get a ruling, Judge? Can she read that?
I'll overrule.
And so your distinction is that he did not include the term swinging the hammer as she moved toward, as she rushed towards defendant 1 and 3 a second time. You say the omission is she didn't include she was swinging the hammer while rushing towards 1 and 3.
My contention is that there is a repeated pattern of her actions being downplayed throughout all the documents. When it looks unfavorable to her, those actions are diminished, and the focus is on the officers.
Okay. And again, your previous statement was it was omitted, but now it was diminished.
Well,
so it's there, isn't it, ma'am?
No, that is diminished.
Judge, I'd ask that he not be yelling at the witness.
Again, ma'am, started this with you told the jury there were material omissions, correct?
Correct.
Okay. And
well, omissions, mischaracterizations, a series of those things, yes.
All right. But
And as we just went over, that second approach or run, as it is, the video speaks, your distinction is that he didn't include swinging.
Swinging the hammer at them. Yes.
That's all I'm saying. He does include that after the shooting, officers entered and attempted life-saving measures for the wounded victim. They put that correct?
Yes, sir.
Pass the witness, Sheriff.
All right, I ask you one question. The defendants were not in clear danger of death or serious bodily injury at the time the defendants used deadly force, nor were the defendants using deadly force in protection of a third party. Is that a correct statement of the law?
Your Honor, I don't mean to interrupt. So is Mr. Litter, you passing and going straight to so we changed
You're crossed. No, you corrected, you crossed.
Got it.
Yes, I'm already directed.
No, the term clear danger of death or serious bodily injury is not a legal standard.
All right, and does that misstate what Chapter 9 of the Texas Penal Code says about apparent danger?
No.
Okay, does the Texas Penal Code Chapter 9 speak in terms of apparent danger as perceived by the accused?
Yes.
All right. And so is what is happening here is that Detective Soto is untruthfully stating what the law is.
Yes.
All right. And so is that egregious in your opinion that he's misstating the law?
Yes, I can't imagine why he didn't use the exact words that are written in the law when he wrote his affidavit.
All right, and he also said after review of available digital evidence, did you understand that phrase to mean all of the body-worn cameras that were uploaded at the time that he signed this affidavit?
That's what it appears he's representing to the magistrate, to me, saying this evidence was available and I reviewed it.
So since we know from the exhibit of the audit trails that all of the 15 officers on scene at the time of the shooting had uploaded their body-worn cameras around 4 or 5 o'clock, they would have been available at the time that he signed this affidavit, correct?
Yes.
And clearly he did not look at all of those 15 videos, did he?
No, he couldn't have.
So is that an untruthful statement in your view?
It's definitely misleading.
All right, and so if he didn't review all of the digital evidence, would he have known what the totality of circumstances were?
No, he could not have known.
And is knowing what the totality of circumstances vital to the issue of justification?
Yes.
That's the witness.
When a detective presents... What? Oh, sorry.
2 seconds. No questions.
Yeah, can I go to... Sorry. When a detective presents an affidavit to a magistrate, does the magistrate have any more than the document to review?
No.
Does the magistrate have the evidence that he or she can look through when they're double-checking, quote-unquote, the document?
No.
Have you heard of the term 4 corners of the document?
Yes.
And all they have are the 4 corners of this document when presented to a magistrate. Is that accurate?
Yes.
I want to direct your attention to page 2 of the affidavit that the government have talked to you about. in the middle of the paragraph, the sentence they didn't want me to ask you about. Starting with as. So does that as victim 1? You see that sentence in the middle? That puts your witness up?
Yeah.
Oh, there we go. As victim 1 moved toward the back door, defendant 1, 2, and 3 fired at the victim, striking her.
So that's the sentence where the detective is educating the magistrate on what actually happened during this alleged crime.
Right.
Fair statement? Now looking at all the evidence, as victim 1, do you, in your opinion, do you believe she moved toward the back door?
No.
Is that an accurate description of what happened when these 3 officers made the decision to discharge their weapon?
No.
Will you explain why that's not accurate?
Because it mischaracterizes what she was doing. She didn't move toward the door. She ran toward the door, swinging the hammer in a backhanded motion. That's quite different than someone moving toward the door.
Now, is this where you're also talking about this? Is there a description in that same sentence describing what she's doing with that hammer? Is it accurate, what we see in these videos?
No, that's my frustration.
So is this what you were referring to the government about when you were saying he left out what she was doing with the hammer at the time they discharged the weapon?
Yes.
Now I want to talk about legal sufficiency because they asked you questions about that. May I stand up, Judge?
Yes.
If a stranger walked up to me and my family and started cussing me out for whatever reason, I know it's hard to imagine, and they were going to say, I'm going to, excuse my language, I'm going to kick your ass in front of your family, and I just shoved them back as they got into my space. And I shoved them back and knocked this person down. And the detective wrote in this affidavit, in the 4 corners of an affidavit, suspect Nico LaHood shoved a complainant down, causing harm to them. So it's an arrest warrant for assault. Would that be accurate?
No.
Would it be important to describe what the true suspect was doing to me when I perceived this threat? And under the same chapter 9, I have a right to use force to defend me and my family.
Yes.
With that affidavit, if that detective in my scenario got an arrest warrant for me, would that be legally sufficient under Chapter 15 to get the arrest warrant?
Yes.
Now also, when in that same sentence, can you read it again? As victim 1?
As victim 1 moved toward the back door, defendant 1, defendant 2, and defendant 3 fired at victim, striking her.
Let's focus on the word striking. Did defendant 1, defendant 2, and defendant 3 strike Melissa Perez?
No.
So, and did he know? I mean, how many wounds? And I'm not trying to be insensitive about this, so please hear my heart. How many wounds were in Miss Perez?
2.
And did Detective Soto know that when he filled out this affidavit?
I don't know, because there were 4 or 5 places in his paperwork that he described her wounds, and he never got them right anywhere. There was always this bizarre mixture. In one place, she was shot in her abdomen. In another place, she had a graze wound to her forehead. Then she had a shot in her chest and her abdomen. In one place, he said she was shot in her back. So I don't think he really could tell us how many gunshots she had, because I don't think he ever knew even after the autopsy.
He testified that he did when he filled out this affidavit.
Yeah, he couldn't have, because the autopsy had not even been completed at that time.
I know he couldn't have, but he testified that he did.
I'm sorry, yeah.
Okay, and is this a sworn statement?
It is.
So you're swearing, just like you swore to tell the truth in front of this jury. He swore to the magistrate judge that the 4 corners of this document were accurate, true, to the best of his ability.
I know.
Did he use the best of his abilities to fill out this affidavit and give accurate information to the magistrate?
I don't think so, because he said that window was blocked by the television when you can clearly see her leaning out of the window to strike with a hammer, and you saw 2 different officers leaning into the apartment, but he characterized that window as being blocked by the television. That's why the officers were safe from her.
And that's why details matter. Is that a fair statement?
Yes, they do.
So, may I stand up, Judge?
Yes.
Would you agree that this printer is an obstruction between you and I? I don't
It's
want to move it.
a partial obstruction.
Well, but if somebody characterized it as an obstruction, like Detective Platt, I mean, would this be an obstruction that could stop me?
No.
Me from going at you?
No.
But under somebody's mindset, could this be described in an affidavit as an obstruction?
Yes.
So is that why you were telling the government and us that details matter and thoroughness matters?
The mischaracterizations are, it's almost like purposeful deception, not quite lying, but definitely mischaracterizing things.
Did you see evidence that the officers had repeatedly attempted to calm Miss Perez down?
Yes.
And actually, Officer Villalobos very calmly just said, "Can you please come back?" Did you hear, what did he say? What do you recall him saying to her?
I don't even recall. There were so many officers that attempted to.
Well, let's talk about that. So, how many officers did you recall trying to attempt to calm her down and get her to come outside?
Rojas, God bless him, he was totally not effective at, Melissa, come out. Melissa, come out. So yeah, he tried.
Okay, and then so how about Ramos?
Ramos acted like a fool. I would definitely disregard him.
But he tried.
He did.
Salinas?
Salinas, yes.
Maria Salinas?
Yes.
John and Maria, correct?
Yes.
How about
Thompson?
Thompson?
Yes. Villalobos, yes. Alejandro, yes.
Sergeant Flores?
Yes. That's 8.
And they tried to have a peaceful resolution.
They pretty much begged her for one, just please come out so this doesn't get worse.
And after they repeatedly begged her, to use your words, and had multiple attempts to peacefully take Miss Perez into custody, did you see her repeatedly attack the officers with weapons capable of causing serious bodily injury or death?
Yes.
Pass the witness, Judge. Hold on, Judge, 1 second. Give me a one over. In your opinion, did she sound more like a schizophrenic individual going through a mental health episode, or someone who was intoxicated who didn't want to be arrested?
Objection leading.
No, she can say yes or no and then explain herself. It's not
He's on direct.
I'll overrule the leading.
Go ahead.
If I had to evaluate her, and all the officers are trained in crisis response, if I had to evaluate her behavior in her apartment, I would say I felt more she was under the influence of an intoxicant. However, when she was talking to the firemen and Officer Rojas first showed up, I would say she was clearly having some kind of mental health
And understanding that
crisis.
dichotomy, that split
Yes.
scenes, the Sergeant Flores, Officer Alejandro, and Officer Villalobos, they were not privy to Captain or Lieutenant Hudson's conversation with Rojas initially.
Yeah, they had no idea that there was even a mental health faction involved in the call. All they saw was her behavior in the apartment.
And you felt that behavior was more of an intoxicated person that was trying to resist arrest with force.
Yeah, that's the way I would have interpreted her behavior.
That's the witness, Judge.
No further questions, Judge.
Witness, do you excuse it?
Anything from the...
Oh, I'm sorry, Tom.
No. No, Your Honor.
All right, you may be excused.
Just before we call the next witness, may we approach?
Sure.
we'd like to